Yeah, my lord, speak to mention, I remember very entire mention the matter when my lord was sitting saying,
Yes.
I have some urgency as far as moving of the stay application. My lord, it's at the bottom of the list, and I'm not sure whether the
What is the
matter.
nature of urgency, Mr. Shan?
My lord, subsequent to the order passed, the disposal of the application under section 34 and execution applications, subsequent orders have been passed by the single judge, on the basis of which the transfer of the immoved property has taken place. I'm more worried about subsequent further transfers takes place and subsequent.
But you can appeal the executive court for that also.
My lord, executing court, I have gone in appeal against the order. That appeal is pending, and that's before Justice Devansh Koshak. My lord is not sitting at the moment. The subsequent orders which have been passed, as far as I'm concerned, that's my submission would be before my lord, that the orders which have been passed subsequent to the disposal of the execution application are all found as official by the learned judge, and therefore
This will appear this will appear on the next Wednesday, immediately after the part advance. Under the same heading, but immediately after the part advance. This is the first matter after the part.
But maybe permitted to mention one matter for collection.
Yes, yes. The original side.
Original set.
This bench. This is the original side matter. No, column no.
item number 1.
Hey, yeah.
Number one. This is my humble prayer to Lord that kindly action this matter.
No, not in a part.
Difficulty is that all the matter which is fixed and
No.
matter and average general visit the state. My lord, difficulty is that only upon instruction. It's my humble prayer. Kindly action for the team. Well, it's my humble lordship. My lord, some of the judgment is cited which is to be distinguished by the advocate general. My lord, kindly adjourn for the team. My lord.
An adjournment is sought on behalf of the respondents, first up as a last chance for the respondents to conclude their arguments. The matter is adjourned till January 21, 2026. First up, it is made clear that in the event the respondents fail to recommence their arguments on the returnable date, the argument of the respondents may be closed.
Yes. On the respondent.
Item number 2.
Yes.
I'm led by Mr. Saha, but I'll start.
This is the last chance we have.
Therefore, I'll start.
Yes.
But we recall, my lord, your lordship had passed an order in this matter at the interim stage. My lord, my understanding is, my lord, having seen the affidavit in opposition, that they have actually not raised any points on the merits. They have only re-agitated the points that were already. I'm not saying it's an interim order, even if they don't file an appeal, they can today, of course, try to persuade your lordship to decide the matter otherwise. But before I start my arguments, I wanted to point that out because they have repeated what they had argued before lordship at the time the interim order was passed. So their main argument is, my lord, on the issue of maintenance. At that, my lord, to address that, my lord, I will go through the background a bit because although that was argued before lordship, but my lord, since some time has passed.
In the final stage.
And anyway, they are going to, if they proceed on the basis of the pleadings, they will also re-agitate the same. My lord, this matter, my lord, concerns the business of a company called Hindustan Storage and Distribution Company Limited. My lord, this company, my lord, is engaged in the business of liquid storage, liquid warehousing, my lord. In it, my lord, the same family, well, this is a very old business, my lord, which has been going on since the time of the Second World War. But subsequently, my lord, around the 1970s, it came into the ownership of the appellant family. They also had another business, which is Bajaj Refineries Limited, which of course, which was in the business of refining. But that, my lord, subsequently the respondent group acquired that business, and the respondent group has an expertise in refining, in running a refinery. Now, my lord, however, the Hindustan's the main warehousing business continued to be with the appellant. However, my lord, subsequently, because of certain business exigencies and financial difficulties, my lord, the appellant entered into a financing arrangement with the respondent side. And my lord, that arrangement, my lord, the first document, my lord, which records that arrangement and the understanding between the parties, my lord, is an agreement dated 15 November 2015, which your lordship will find at page 101.
Financing arrangement in the sense that they would finance you.
They gave us certain financial accommodation. So initially, my lord will find that in 2015, my lord, the understanding was focused on returning the money.
All right.
So, my lord, will see this minutes of meeting between Mr. Alok Saraf and Mr. Vijay Agarwal on 15 November 2015. Alok Saraf, my lord, is the appellant, my lord. Mr. Alok Saraf has made the following proposal to Mr. Vijay Agarwal. Existing oil installation business of HSDCL along with tank, pipelines and 5 acres land free from all liabilities will be transferred to a company in which BBRL, which is Bajaj Refinery Limited, by this time, my lord, that is already, my lord, under the control of the respondent group, shall give. Sir, no, please. No.
So we had just started with the MOU at page 101.
Yes, sir. But so far as this matter is concerned, I think we can narrow it down. Look, there is a memorandum of settlement. So far as the memorandum of settlement is concerned, that follows an agreement for mediation. There was a mediation. The mediator prepared the terms of settlement. The terms of settlement is included by both parties. We ultimately assume that it had attained the character of an award under Section 74 of the Arbitration Legislation. Accordingly, there was an application made for execution. The only ground on which the executing court felt that this is not executable is because the memorandum of settlement also had an arbitration clause. And so the court was of the opinion that in view of the fact that there is an arbitration clause, it has not attained finality. Of course, that is a different now. However, so far as that is concerned, that was taken up in challenge before the Court of Appeal. The Court of Appeal felt that no appeal was maintainable because it was a commercial matter. There was a bar under Section 13. So the Court of Appeal dismissed the appeal, saying that the appeal is not maintainable. Against that the SLP was spread. Ultimately, that SLP was withdrawn because the Supreme Court felt that we should pursue a challenge to an independent SLP that was filed against the order passed by the executive court. That is now pending. So the dispute really is whether that mediated settlement has resumed the character of an award or not. Now, undoubtedly, so far as the mediated settlement agreement is concerned, I should show you lordship that whether it has assumed the air or character of finality or not, there is absolutely no doubt.
What is the present challenge against Mr. Shah?
I just said, there is no doubt that it's an agreement. Now, the agreement provides there are two groups. The petitioner group is the ASA.
No, in the sense that SLP went up to the SLP. What was dismissed? Your execution application.
Well, my execution application was dismissed.
Okay. So now what have you challenged?
Now, the execution application has been dismissed on the ground that there is a arbitration clause in the settlement agreement. So, it has not assumed the air of finality or character of finality under Section 74 of the arbitration, which says the mediated settlement has the character of an award. Now, that is pending before the court of appeal. In the meantime, irrespective of whether it has assumed finality or not, it is undoubtedly an agreement between the parties.
Well, that agreement contained the provision for transfer of certain shares in a company called Hindustan Cooperative to buy one group to the other. The transferor group is the ASA group, the transferring group is the EPI.
You are ASA.
And the ASA group. The ASA group said that we will transfer our shares in the company to, however, there are certain businesses, of storage of liquid oils and fluids, which will come back to us. Now, this was agreed because there are two entities. One is called Total, one is called Super Spirit that will carry on business from the properties, the tankers, etc. that will be directed in the property. May I just show you Lordship that one clause? If you Lordship will please come to the settlement agreement, memorandum of settlement, that starts at page, say application volume 1, page 120. I just want to show you Lordship one clause of that. Or may I just show you Lordship the settlement agreement? This is the memorandum of settlement.
Yes.
Now, so far as this settlement agreement is concerned, you'll also find at page 121.
This is the one which you said was a final level.
Yes, final. Because this memorandum of settlement was made pursuant to an agreement for mediation. Just for your Lordship's record, the agreement for mediation is at page 111. What followed the agreement of mediation is the mediation which resulted in the memorandum of settlement. Now, the memorandum of settlement contains several terms. May I straight away request your Lordships to have a look at page 134, clause 20.
Yeah.
Clause 20, may I place it? It has been mutually agreed that the business of Total and Super Spirit that has been carried on till now in the name of Hindustan shall belong to the ASA group with immediate effect. And the parties shall immediately inform this to Total and Super Spirit and take all necessary steps and sign all papers and documents for transfer of such business to an entity of the ASA group to be specified by the ASA group. Till such transfer is formalized, the business with Total and Super Spirit shall be continued without stoppage in the name of Hindustan, though the revenues shall belong to the ASA group and shall be paid by the EPI group to the ASA group after retaining a mutually agreed amount for use of tanks for such period. The ASA group may either build new tanks on ASA group land or purchase tanks of Hindustan from the EPI group at a mutually agreed amount and shift them to the ASA group land. The parties shall consider the possibility of the tanks presently being used for the business of Total and Super Spirit remaining where they are at present, and allotment of the land to which the same are located to the ASA group along with the said tanks. In such an event, the area of the land so allotted shall be adjusted against the land area to be allotted in view of the RGSF land mentioned in clause 27 of the mutually agreed price of the tanks and infrastructure shall be paid to the EPI group by the ASA group. The decisions regarding the matters mentioned in this clause shall be taken within 30 days. Well, this was the agreement. Also, clause 27 is relevant. Please also have a look at clause 27.
Yeah.
Out of the ASA group land of 14.3724 acres, some lands allotted and belonging to RGSF, which were in front roadside portion, have been used for construction of new tanks by the EPI. Accordingly, it has been mutually agreed that A, in lieu of the same, 125% of such used land area shall belong to RGSF out of the lands allotted to PI group, taking into consideration the premium location of the land of RGSF that has been used and to compensate for the same. And B, the land of RGSF utilized by EPI group shall form a part of 66 acres of land belonging to the EPI group.
What is the RGSF?
Well, RGSF is one of the group companies.
So it's a third entity.
Yes. No, it is
with you.
There is with me. There are now two groups comprising of individuals and companies. Now, all that I'm trying to say is there was to be adjustment of land and transfer of business. Now, so far as this is concerned, when we wanted to enforce this memorandum of settlement, the clause that stood in the way is clause 50. Please have a look at clause 51.
Yes.
This is the dispute resolution clause. It says, in the event there are any disputes and the differences between the parties here too, regarding this agreement. So, this agreement is final. Including any question regarding its existence, validity or construction, interpretation of any of the terms and conditions herein contained, or touching this presence and the termination of this agreement, or determination of any liability or obligation of the claim balance shall be first attempted to be resolved by the parties through negotiation and then now when we
Give us half a second.
Yeah.
তোমাদের কাছে কোনো tag আছে? আচ্ছা, tag নেই।
now in view of this agreement,
Yes.
when we thought that this was final and had resumed the character of an award, we filed for execution. One of the prayers in the execution application concerns this business. Please have a look at the execution application that starts at page 70. The tabular statement is at page 69. I only want to show you one prayer in the tabular statement, that's prayer J. Prayer J at page 69. Let me just read this one prayer.
Yes.
An order of mandatory injunction be made directing the respondent number 8 to provide to the petitioner number 3 and the nominees of the ASA group account of all business transactions of the total which supersede on and from such and to make over to the petitioner the revenue earned therefrom, etc. So this was one of the prayers because this was the agreement between the parties. Now naturally we could not get this order in execution because the court was of opinion that it is not executable because it's not really an award. Now in the meantime, what happened is there were letters that were written by the EPI group saying that we are terminating total and we are terminating superscript. These letters you'll actually find at page 240 on.
That would be contrary to the
terms of the
settlement
agreement. Now these letters are there, pages 240, 241, 242, etc. I'll not trouble you with the text of the letters. Because here they clearly said that we are going to terminate these businesses, which would operate to our prejudice. Now, at this juncture, we came up and filed an application under Section 9. Our contention was very simple. If it is an award, in that case, Section 9 applies at 3 stages, before, during, and after. If it is not an award and simply said an agreement containing an arbitration agreement, in that case, also Section 9 applies. So, therefore, I need protection because this is the express agreement of the parties as recorded in the memorandum of settlement that these businesses will come to me. In the meantime, these businesses will be carried on. You will maintain an account of the revenues, transfer the revenues to keep a percentage of operational. Now, when your lordship heard this matter, initially, your lordship was pleased to pass an order on the 24th of September 2025. This really ultimately considers the question as to whether this application under Section 9 is maintainable and we are entitled to maintain it. This came up for consideration because the learned single judge who has been looking at that since we have said that it's an award and we are seeking execution of the award and have taken up this challenge before the Supreme Court, we are not entitled to pursue that. But my submission to your lordship is very simple. But if the Supreme Court ultimately holds that yes, it has assumed the characteristics of an award and is executable as such, then I will naturally proceed to execute the award. Now, Section 36 has not yet become really available to me because ultimately there was has been held to be not executable as of now. But nonetheless, either which way I look at it, my contention with your lordship was that this is ultimately something that would entitle me to a protection under Section 9, irrespective of whether this is an award or this is still an agreement.
Mr. Shah, the last order which stands in respect of that execution case is the order of the learned single judge verdict. That it is not a. So as of today, you may argue that the legal position is, unless you win the SLP, that it's not an award.
That's it. Well, that is exactly my case.
So, but I have maybe contrary to your stand, but the legal position as of today is that it is not yet an award.
And that is exactly what your lordships have held, while ultimately admitting that we are passing an impediment. May I request your lordship, please have a look at your lordship's order of 24th September 2025. Well, this question was considered by Lordship because when ultimately this was an order passed on contest. And when your Lordship has clearly held.
If you have a copy, you can give it. She's giving it to us because we can mark there. Thank you. We have the order, but it will be easier to mark on this one. Yes.
At page 2, when the Lordships have noted in the second last paragraph, where the arbitration clause, which is the spoiler in the game. I mean, so far as this is concerned, you'll also see thereafter, the last paragraph at page 2. All the apparently the learned single judge refused the pair of the appellant on the ground that previously the appellant had taken the stand. That the award passed in the mediation was the final award and execution lies, the said issue is subject matter of challenge in the appeal itself, and as such, we are not examining the same. But at that point of time, the appeal before the division bench of this court was.
Yes, it was pending.
However, we find from the provisions of section 13(1)(a) provides that the challenge under section 37 of the 96 Act is also maintainable under the said provision against the interlocutory order within the contemplation of section 9. But because the question of appellability was raised before your lawsuits as well, but under section 37 is appellable under the commercial codes. Since the addendum model was passed by the learned single judge is appellable under section 9 of the 1996 Act or not, an appeal is mentioned. The proposition laid down in Shamsteel is not applicable. Then the next question. The dispute involved in the appeal is in connection with the purported memorandum of settlement dated 10 September 2024, arrived at between the parties in a mediation proceeding. Whereas the appellants contend that the same was in the nature of a final award by way of settlement in mediation proceeding, respondents dispute such contention and submit that the said agreement was merely a preliminary step in attempts of the parties to arrive at a settlement, but not a conclusive award. Appellants have admittedly sought to enforce the said settlement agreement by deeming the same to be a final award passed in mediation. However, a learned single judge of this court, while dismissing the said enforcement application under section 36 of the 96 Act, where such and such by a judgment dated 30th May 2025 observed inter alia that the settlement did not tantamount to a final settlement within the contemplation of the arbitration and conciliation act 96, therewith order 21 of the Code of Civil Procedure. The appellants in the meantime preferred a challenge against the said order dated 30th May 2025 before a division bench, which challenge was dismissed by a division bench, upon which a special petition has been preferred by the appellants before the Supreme Court, which is now pending. Counsel for the appellants argued that even if the agreement is not construed as a final award, provisions of section 9 of the 96 Act are applicable and operate till the award is finally enforced. Even otherwise, section 36 of the 96 Act would entitle the appellants to execute the award. By the order impugned, an application filed by the appellants for injunction in terms of clause 20 of the agreement was turned down on the ground that the appellants themselves have treated the agreement to be a final award and cannot now resile from such position and treat the same to be an arbitration agreement, leaving it open for the appellants to take recourse to the arbitration and seek a relief under section 9 of the 96 Act. Upon careful consideration of the argument of the parties, we find that the respondents are prima facie justified in arguing that the appellants cannot take the benefit of the best of both worlds, simultaneously treating the agreement between the parties to be an enforceable final award passed in the mediation, and on the other hand, treating the same to be merely an agreement between the parties containing an arbitration clause which would comprise the genesis of a dispute in arbitration. However, even if we accept such submission of the respondent, the court, when approached for protection, enables relief sought on the basis of a particular clause of an agreement, which contains an arbitration clause, cannot shut its eyes due to the mandate of section 9 of the 96 Act. The scope of section 9 is wide enough to encompass disputes between the parties, where there is an arbitration agreement between them at any time after the making of an arbitral award, but before it is enforced in accordance with section 36. In the present case, if we deem the agreement between the parties to be a final mediation award, having the effect of a decree, still then, the award has not yet been enforced, thus leaving it open for the parties to take recourse to section 9 of the 96 Act. The initiation of an enforcement proceeding under section 36 of the 96 Act cannot be equated to an arbitral award having been actually enforced. The term enforced used in section 9(1) contemplates undoubtedly a situation where the award has already been enforced, thereby giving a terminus to the arbitral proceeding, and not a situation where the award is yet to be enforced and only an initiative has been taken for such enforcement. Even otherwise, we proceed on the premise that the agreement between the parties is not a final settlement and a final award passed in mediation. The respondents themselves have referred the dispute to arbitration by issuing a request under Section 21 of the 96 Act, apparently pursuant to an observation made by the division bench in the challenge against the order dated 20th May 2025. Even if the appellants have refused to accede to such request, fact remains that the existence of the arbitration and of the agreement containing the same is not disputed by either of the parties. The dispute is whether the said agreement tantamounts to final settlement in the mediation and has effect on the. Thus, even if the agreement is not deemed to be a final settlement between the parties in mediation, the existence of the agreement, including the arbitration clause contained therein, justify protection being given to the court given by the court under Section 9 of the 96 Act. As such, either way, whether the agreement between the parties is ultimately found to be a final award in mediation or not, existence of the arbitral clause remains, and the disputes under the said agreement are referable to arbitration. There is a sufficiently strong prima facie case under the lordship soul, then under the next paragraph. In view of the fact that the existence of agreement comprised with the purported settlement between the parties has not been disputed by and between any of the parties, and in view of the said agreement containing an arbitration clause in clause 50 thereof, whereof opinion that till the issue is resolved as to whether the agreement tantamounts to a final settlement or not, the dispute between the parties under such agreement remains alive, entitling the appellant to protective orders paid for on the strength of clause 20 of the agreement between the parties. Even otherwise, balance of convenience is in favor of grant of injunction and under the lordship that thereafter these two parts in order.
There was no challenge to this.
No challenge. Now, after that, however, my relatives filed their affidavit first with leave of court. So, may I just show you, Lordship, what their grounds of opposition is? And if you, Lordship, please take up the opposition filed in the proceeding. Just 3 or 4 paragraphs. This is an affidavit by Mahesh Kinkar Pandey.
Yes.
Can you come to paragraph 4?
Yes.
So let me just read paragraph 4. The second sentence. What is important to note here is that the stay sought for is in the nature of an order which tends to undermine respondent number 8's right to make autonomous business decisions according to its own commercial freedom. And then if your lordship skips over the subparagraph and comes to the next subparagraph, I state that the team proceeds on the basis that the settlement agreement purportedly dated 10 September 2024 is in existence. However, such agreement cannot exist in law because the purported agreement could not have attained finality in law since Section 71 to 78 of the Arbitration Control Act clearly spells out the procedural rigors mandatorily to be complied with for any settlement agreement to be executed. Here, in the instant case, there is clear deviation from the procedure established by law to reach the settlement. Then, Miller, please have a look at paragraph 6. I further state that this honorable court by a judgment dated 28 May 25 has already ruled that there is any agreement, that there is any agreement and certainly no mediated settlement agreement between the parties. Therefore, the appellants cannot make out a case for protection of any rights flowing from such purported agreement, which stands as an honest document in the eyes of law after the judgment of 28 May 2025. Then paragraph 7. I state that if there is no agreement and a mediated settlement agreement with law, and there cannot be any reward in terms of Section 74 of the said Act, hence no Section 9 application can be maintainable to enforce any of the clauses of the purported document dated 10 September 24. However, the arbitration agreement contained in clause 50 is a separate and independent agreement. Said clause permits reference to arbitration challenging the existence, validity, or construction and interpretation of any of the terms and conditions contained in the document dated 10 September 2024. Therefore, such clause itself makes it clear that none of the terms, except for the arbitration agreement, is valid and binding or enforced. And finally, paragraph 12. The ad interim order dated 24th September 2025 proceeds on the basis that there was an agreement, which in my humble submission is a status that cannot be accorded to the purported agreement. Therefore, in my humble submission, the ad interim order dated 24th September 2025 cannot be confirmed or extended. But this is really the substance of my defense. I don't wish to trouble your lordship further. Now, the question, as to whether the application or challenge is sustainable, your lordships have already held. The question as to whether the clause exists, clause 20 exists, which makes it obligatory, award or no award, to transfer the business of professional super spirit to me has not been denied. However, the attempt is to deny the agreement altogether. Now, if the clause stands and the matter as to whether the agreement exists, does not exist, will have to be finally decided in arbitration. Then, my rights under the clause have to be protected.
Mr. Shah, we'd like to, you can proceed in your own way, but we'd like to look at two documents. One is the first order of the London single judge, which is now under challenge.
Yes.
That, and if you have a copy, their reference to arbitration.
Yes,
on the strength of this.
The order of the London single judge, the first order, page 21. So this is the order of the single judge, page 21.
Yes.
This is the single judge's order, and the notice of reference to arbitration that you'll also find in the reply, page 29.
So in para 7, they rely on that arbitration agreement itself,
Yes.
obviously.
But while relying on the arbitration agreement, they might have want to discard the rest of the agreement. The question is not whether the rest of the agreement exists or doesn't, because it is signed by the parties. The question is whether, because of the arbitration clause, it will attain that finality. But
the arbitration clause also says that disputes relating to this agreement.
No.
That agreement.
Three things. Dispute relating to existence. Now, when the parties sign the document, there is no dispute with regard to existence. Because the Supreme Court has now held that when parties execute a document, it is later not open to them to say that I have not executed the document. Unless they say this is procured by fraud or is a result of coercion or duress. Now, that is not the case.
So the legal effect of the agreement may be in question.
Yes.
Execution.
Existence is not in dispute. Now, validity would be in dispute. That is the next expression. If it is regarding an illegal drug, a gambling agreement. Well, so validity is not in dispute. They have not disputed the terms of the agreement. Or they have not said any dispute arises out of the terms of the agreement. They have simply said we have signed it in good faith. That is all that they have said. Well, with all greatest of respect, even if 50 survives, because your lordship sees the memorandum of settlement, the clauses preceding clause 50 and the clauses succeeding clause 50 say in express terms, agreement is final, it is valid, it is binding on us, we will not challenge. Now, today, if these clauses are there, then I should be arguing for the Supreme Court that this has attained the error of finality. And what are the disputes that can be referred? Are disputes that arise out of this agreement in the manner of contemplation of what its terms actually mean. But that dispute has not even been raised in the case. So whether that is a matter for argument for the Supreme Court. But notwithstanding that, the fact that clause 20 exists and that obliges transfer of the business and obliges continuation of the business till such time that the transfer can take effect. But it's something that would entitle my license to stop the business. Now, notwithstanding the fact that your lordship were pleased to pass that order of injunction, well, ultimately a situation had come to pass when they had created such a situation that one of these two entities had to pack their bags and leave. Only when the other entity is there. But that is not on record. I will not trouble you with that. Well, the question is whether the interim order should now be continued and the appeal be allowed. Well, this is really the short a short prospectus of the matter. Nothing more than that. Well, these are my statements.
I would like to rely on anything.
Well, the decision I rely on is your lordship decision at the interim order stage because the section is very clear.
Shamsil was relied
Well,
on by-
that is on the question of appellate.
that has been
Yes. I really don't want to cite any judgment because the question of what is the scope of section 9 is in the section.
interpretation of the section and the clause.
Yes, that's all.
Kindly take up your lordship's order or the order of 24th September 2020.
Yes. Yes.
Kindly come to the third page ballot, possibly the page of tally. Not very certain. The penultimate paragraph starts with the appellants have admitted. The appellants have admittedly sought to enforce the said settlement agreement by deeming the same to be a final award passed in the mediation. However, a learned single judge of this honorable court, while dismissing the said enforcement application under section 36 of the 96 Act, bearing such and such, by a judgment dated 20th May 2025, observed inter alia that the settlement did not tantamount to a final agreement within the contemplation of the Arbitration and Conciliation Act. Then turning the page. The appellant in the meantime preferred a challenge against the said order dated 20th May 2025 before a revision bench, which challenge was dismissed by the revision bench, upon which a special petition has been preferred by the appellant before the Supreme Court, which is now pending, that is still pending. Learned senior counsel appearing for the appellant argues that even if the argument is not construed as a final award, the provisions of section 9 of the 96 Act are applicable and operate till the award is finally effective. This is has been taken care of by the penultimate paragraph. Even otherwise, section 36 of the 96 Act would entitle the applicant to execute them. By the impugned order, an application filed by the applicant for injunction in terms of clause 20 of the agreement was turned down on the ground that the applicant themselves, having treated the agreement to be a final award, cannot now resile from such position and treat the same to be an arbitration agreement, leaving it open for the applicant to take recourse to arbitration and seek a relief under section 9. Upon a careful consideration of the argument of the parties, we find that the respondents are prima facie justified in arguing that the appellants cannot take the benefit at the best of two worlds. Simultaneously, treating the agreement between the parties to be an enforceable final award passed in mediation, and on the other hand, treating the same to be merely an agreement between the parties containing an arbitration clause, which would comprise the genesis of a dispute in arbitration. Now, my lord, I don't think that this has been, my lord, addressed before your lordship, at least, my lord, till when, my lord, I was here, my lord, I did not hear again. Then, my lord, kindly turn the page. Then, my lord, your lordship's observations. The scope of section 9, page 5, my lord,
Yes.
at the top.
Yes.
Scope of section 9 is wide enough to encompass disputes between the parties where there is an arbitration agreement between them at any time after the making of the arbitral award, but before it is enforced in accordance with section 36. in the present, if we deem the agreement between the parties to be a final mediation award, having the effect of a decree, still then the award has not yet been enforced. Now, my lord, this is the basis on which this interim order was passed. Now, my lord, I need not challenge, my lord, all interim orders when, my lord, the application is pending. That is, my lord, not a final order. So merely because I did not challenge this order, my lord, cannot, my lord, preclude me from challenging it now or saying that
Yes.
kindly modify this.
Yes.
The initiation of an enforcement proceeding under Section 36 of the 96 Act cannot be equated to an arbitral award having actually been enforced. The term enforced used in Section 9(1) contemplates undoubtedly a situation where the award has already been enforced, thereby giving a terminus to the arbitral proceeding, and not a situation where the award is yet to be enforced and only an initiative has been taken for such an end. Well, this is the point, your lordship, on the last occasion, my learned friend was not there, was also pleased to point out. Now, let's kindly look into section 36. Enforced. When the time for making an application to set aside the arbitral award under section 34 has expired, then subject to the provision of subsection 2, such award shall be enforced. Not while proceeding shall be initiated. Such award shall be enforced in accordance with the provisions of the Code of Civil.
So the intention of the
Intention is by the initiation. And that is exactly. Now kindly come back to section 9. Kindly come to section 9.
till it is enforced in accordance with section 30.
Yes.
Before it is.
So, my lord, if my lord, it has to be construed that, my lord, the execution has to, or my lord, the enforcement has to be completed, then, my lord, nothing would remain for execution. Because in execution, my lord, scope of section 9 is very limited, as prescribed under section 9. Whereas, my lord, under section 36, or my lord, under the Civil Procedure Code in execution, my lord, the scope is much wider. That is why, my lord, the idea is kindly look, my lord, entirety, my lord, section 9 in its entirety. Before, my lord, arbitration commences, then arbitration, and then before it is executed. Now, my lord, in my full submission, the word, my lord, executed means, my lord, initiation of execution.
After you finish this line of argument research, Victor will ask you another question. And ask you, is that right? Suppose we accept your argument that this enforcement is the initiation. Now the position now is that they take a stand that it's a final award. And you take a stand, otherwise we are not bothered with you at the present moment. It's them who are seeking in section 9 has been final. So in their perception, it's a final award, and that is their consistent stand.
Yes.
The question is, Mr. Mitra, for a section 9 court to adjudicate a section 9, whether their perception is important. Because why we say this? Because the section 9 court will look into the parameters of whatever is there in section 9. As of today, The position of law is, the legal position is that a learned single judge has refuted their contention that it's a final conclusive. Till now, that has not been upset. Although they are challenging from their perception, you are right. But that is not the legal position as of today, till date. What has been held is that it's not a final hour. Therefore, we go by their perception for the purpose of exercising the scope of exercising under Section 9. Or the Section 9 could look at only what is the present position in law. Yes.
Now, my lord, this is exactly where, my lord, the doctrine of election comes in. My lord, they cannot on the one hand say, my lord, as well as recorded in the order.
Election may be issue estoppel in a sense.
That is again, my lord, part of election, or election is part of that.
Yes.
Now, they say, till now, they say that no, it is an award. I'll show you, Lordship, my lord, my client had made an application under Section 11. Before that, correspondence referred to arbitration. Nothing happened. Section 11 opposed, direction given for arbitration.
So there obviously their consistent stand is that it's a
Then, my lord, they have to.
that is there because their SLP is still pending.
They have to, my lord, they cannot, my lord, take, my lord, the advantage as recorded by your lordships. They cannot take advantage of, my lord, both.
So they cannot invoke Section 9.
They cannot.
So unless they can invoke Section 9, the threshold is not crossed for the Section 9 court to look into.
Section 9 treating, my lord, the agreement to be a mere agreement
Yes,
is
exactly.
not an award.
Right, right. But Mr. Shane, wouldn't then the principle of UBJ's IB remedium apply? Because 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 if they can't treat it as a either way, because the legal position is that today it is not a final award as per the last finding of a competent court. Now they cannot invoke Section 9. Now they'll be altogether without any remedy. That is what we were thinking, because they are precluded from their own by their own stand. On the one hand, on the other hand, they are precluded by the observation of the court. They cannot come up and say that yes, it's not a final award itself.
They are not without remedy.
So it's a dog in the manger
They are not,
sort of
they
scenario.
are not without remedy. But as I have submitted,
That's two only.
I have made a, no, they could have said, yes, this is an agreement.
So that we cannot complicate to that.
That is exactly what, my lord, now today, my lord, when I make an application under Section 11, they take this stand that no,
It's a final.
yes. No, they, my lord, in my submission cannot do this. They have to choose. Today, I cannot proceed with the arbitration because Section 11 is opposed. Direction has been given for
That will
filing.
be different. But you have invoked and you are proceeding with it. You have taken your legal recourse.
I'll show you, Lordship, my lord, if required, my lord, the correspondence exchange. They
No,
also,
they are consistently saying that it's not a.
they partly agreed.
Oh.
They partly agreed. No,
Partly agreed won't help you in this case. Their partial agreement would go against you in this case.
that is exactly what they
So
did.
let us not.
Now, may I, my lord, on this point,
Yes.
my lord, that executed. May I rely on a judgment of the Bombay, a division bench judgment of the
Absolutely.
Bombay High Court, my lord, reported in 2013, SPC Online Bombay 48. But kindly come to one paragraph, paragraph 4. One thing.
Yes.
But kindly give me.
Yes,
I'm not
absolutely.
very conversant
No,
with
please
this.
take your time. Absolutely.
We come to paragraph.
Yes, please.
Two facets of section 9 merit difference. The first relate to the nature of the orders that can be passed under clause 1 and 2. Clause 1 contemplates an order appointing a guardian for a minor or a person of unsound mind for the purpose of arbitration proceeding. Clause 2 contemplates an interim measure of protection for A. The preservation, interim custody or sale of any good which is the subject matter of the arbitration agreement. B. Securing the amount in dispute in the arbitration. And C. The detention, preservation or inspection of any property or thing which is the subject matter of the dispute in arbitration. D. An interim injunction of the appointment of a receiver. And E. Such other interim measure of protection as may appear to the court to be just and convenient. The underlying theme of each one of the subclauses of clause 2 is the immediate and proximate nexus between the interim measure of protection and the preservation, protection, and security of the subject matter of the dispute in the arbitral proceeding. In other words, the orders that are contemplated under clause 2 are regarded as interim measures of protection intended to protect the claim in arbitration from being frustrated. The interim measure is intended to safeguard the subject matter of the dispute in the course of the arbitral proceeding. The second facet of section 9 is the proximate nexus between the orders that are sought and the arbitral hearing. When an interim measure of protection is sought before or during the arbitral proceeding, such a measure is a stay in aid of the protection of the arbitration proceeding. When sought after an arbitral award is made, but before it is enforced, the measure of protection is intended to safeguard the fruits of the proceedings until the eventual enforcement of the award. Here again, the measure of protection is a step in aid of enforcement. It is intended to ensure that enforcement of the award results in a realizable claim and that the award is not rendered illusory by dealing that would put the subject of the award beyond the pale of enforcement. At any time after the making of the arbitral award, but before it is enforced in accordance with section 36. Under section 36, an arbitral award can be enforced under the Code of Civil Procedure in the same manner as if it were a decree of the court. The arbitral award can be enforced when the time for making an application to set aside the arbitral award under section 34 has expired, or in the event of such an application having been made, it has been refused. The enforcement of an award inures to the benefit of the party who has secured an award in the arbitral procedure. That is why the enforceability of the award under section 36 is justifiable in the context of two time frames. The first being an application for setting aside the arbitral award has expired, and the second where an application for setting aside an arbitral award was made but was refused. The enforceability of an award, in other words, is defined with reference to the failure of the other side to find an outcome.
If it is in aid of enforcement, Mr. Mitra, then it rather supports the proposition that enforcement happens only when it is final. Because if section 9, then as per this judgment, section 9 is maintainable during the enforcement proceedings also. Because if it is in aid of enforcement.
In aid of enforcement, it would be enforced.
In aid of enforcement, yes, that intended to ensure that enforcement of the award results in a realization claim.
Because, my lord, for the simple reason, my lord, kindly appreciate, my lord, all the, my lord, reliefs which can be granted in section under section 9, my lord, can be granted under, my lord, the civil procedure, which is 36 and particularly civil procedure code, where, my lord, scope is much wider.
And the 36 code grant the section 9 reliefs, apart from only stay which is contemplated in 36(2). The enforcement code, the execution code, in respect of an arbitral award, can it grant any other order than stay? Can the executing code under section 36 pass any of the orders apart from stay, which are contemplated in section 9?
36 would be enforced in terms of civil procedure.
36 is the enforcement. 36(2) in a roundabout way says, unless the court grants an order of stay of operation of the arbitral award. But is any power vested in the section 36 code to pass any of the reliefs as contemplated in section 9?
36 could possibly no.
If not,
Yes.
then going by the logic of the Bombay High Court, Mr. Mitro, how could, I mean, section 9 can come to the aid of enforcement. That is of a, the rainbow is larger than the powers of an executing court only. So therefore, going by this event, if it is section 9 is in aid of enforcement, then all sorts of powers which are given in section 9 in aid of enforcement, that ultimately it reaches fruition, that should be, section 9 should be available during pendency of the section 36 also then, going by this judgment. If it is in aid of enforcement, it's not in aid of filing of an enforcement application. It's not an section, here it has not been held that section 9 is in aid of filing of an enforcement application. That which is
not required, but in my
yes.
filing is something different.
Right. Obviously, it would be an absurd interpretation to say that section 9 would be in aid of initiation of an enforcement. So, section 9 here it has been held is in aid of enforcement so that the award reaches fruition. Award cannot reach fruition unless it is finally enforced, and the award reaches culmination by way of an actual enforcement. So, even going by this logic, Mr. Mitro, it would be counterintuitive to hold that section 9 is available in aid of execution, enforcement, but it will not be maintainable during the pendency of the enforcement proceeding, unless it is actually enforced. Going by this language only, if it is a measure of protection intended to safeguard the fruit of the proceedings, fruit can only be obtained, Mr. Mitro, when it is finally enforced. If it is in aid of that, then unless the fruit is obtained.
In aid of.
Yes, in aid of.
In aid of, whether that, as I have submitted before your Lordship, I am possibly repeating. Now, whether this relief, can be granted, in execution also. I could have understood.
That is the question we put to you, Mr. Mitro. Can the executing court, barring stay of operation under 36(2), grant any relief within the contemplation? Executing court under order 21 can grant.
Kindly come to section 36(1)(1).
Yes.
When the time for making an application to set aside the arbitral award under section 34 has expired, then subject to provision of subsection 2, such award shall be enforced in accordance with the provisions of the Code of Civil Procedure.
Enforced in accordance with the provisions of, but all the provisions of the Civil Procedure Code cannot be applicable. Then, Mr. Mitro, we have actually held in another judgment. Then order 21 rule 97 to 101 would be applicable. Going by that logic, all the provisions relating to touching execution or flowing out of execution are not applicable. CPC is applicable only in accordance, such as order 20 rule 32, that modality or the other modalities depending on the nature of the award. So only the provisions for enforcement, as in enforcement, like order 20 rule 32, we give a rough example, or the modality of enforcement as provided in CPC can be applicable. But not all provisions under order 21. It's not an umbrella provision covering all other provisions. Because otherwise, Mr. Mitro, you just contemplate a situation, section 36 is a superior code. I mean, in a sense that section 36 code takes up section 34 also from the award. So there it is being enforced. If order 21 rule 97 to 101 is operative there, it would become the first code. And an appeal second miscellaneous appeal would lie. So that will be opening up a hierarchy which is not contemplated in the 1996 Act. Therefore, all provisions cannot apply, only regarding enforcement.
Absolutely.
And 36(2) makes an exception, stay of operation. It directly does not say that. Directly, that is also not a direct power. Unless the court grants an order of stay of operation of the arbitral award in accordance with the provisions of subsection 3. And subsection 3 is the mother power, parent power. An application for stay of operation, the court may subject to such one. This is the only power given under section 36 to the executive court. So then, read in conjunction or juxtaposed as used by Justice Chandra, we are borrowing that expression from this judgment only. And if it is juxtaposed with this ratio, then what we held is, is supported in a sense. Because if it is in aid of the enforcement, to get the fruit of the award, fruit can only be obtained when it is enforced actually. Then section 9, Mr. Mitro, would be in aid of would be the rainbow would be larger, as we say, than executing court powers. But yet, Mr. Mitra, this language of section 36(1) is also there. The way the legislature has contemplated the word enforced. Even if you overlook the judgment from the High Court judgment, or we look into it, section 36(1) language still remains your first argument.
Absolutely.
Such awards shall be enforced in accordance with the provisions which apparently implies put into execution in the civil sense.
Can I, my lord, make a prayer? May I work on it, my lord, some further and come back? Well, I know, my lord, that upsets everything, but because
We cannot go, whatever you think about Mr. Mitra, it would only lead to loops and repetitive thinking. Ultimately, that will be a legal OCD. So we cannot improve or expand from this. Whatever is there in this judgment, we have discussed right now.
no, if
No, we
if
can-
we can find out anything.
We can, first of all, Mr. Mitra, we can read this judgment in light of section 36(1). 36(1), in our perception, 36(1) language is your strongest argument right now. That perception may change subject to what you say. Shall be enforced in accordance with the provisions apparently means put into execution. So therefore, if that is the way the legislature thinks it to be, then there cannot be two meanings of enforcement in 9 and 36, which is a very strong argument. I mean, we have to think of, if we accept what we said earlier, we have to overcome this. And if this overcomes us, then we don't accept what you.
Can I come back?
Mr. Mittu, this is a part of this is a very
Very,
short
very,
compass.
very.
Whatever is there is there.
Very. May I, my lord? In this context, my lord, may I also rely on another Bombay
Absolutely.
judgment, my lord, but it's a sin.
So what? So what? This is Justice Girish Kulkarni.
Yes. Kindly come to paragraph 23 onwards, my lord, the discussion. Having heard the learned senior counsel for the parties and having perused the record, At the outset, some admitted facts are required to be noted. It is not in dispute that although the award is dated 26 June 2015, given after coming into force of the amended provisions of Section 36, there is no application filed by DSM saying for stay of the award which is admitted in the nature of a money due. It is also not in dispute that HAL on 22nd September 2015 filed an execution application to execute the majority award. The execution application had remained pending for almost 4 years till the same was withdrawn by HAL on 21st February 2019. It is also not in dispute that during the pendency of the execution application, HAL on 13th December 2016 filed a Section 9 application praying that DSM be directed to deposit the award amount of such and such, which came to be rejected during the pendency of the execution proceeding by an order dated 29 September 2017, passed by the learned district. This order was challenged by HAL approaching this court in a Section 37 appeal. HAL, after almost 17 months of the rejection of the said application during the pendency of the Section 37 appeal, thought it appropriate to file an application on 21st February 2019 to withdraw the execution application. This court consequently disposed of HAL's Section 37 appeal by an order dated such and such, remanding the matter back for consideration of the Section 9 application, keeping all the contentions of the parties open. On this admitted factual conspectus, the point which arises for consideration in this proceeding is whether the learned district judge in the facts of the present case had jurisdiction to entertain HAL's Section 9 application when the arbitral award dated 26 June 2015 had become enforceable, as admittedly DSM has not filed any application seeking stay of the arbitral award as per the requirement of the amended provision. To determine the above question, it would be necessary to consider the scope of jurisdiction of the Section 9 of the Act. Section 9 provides for interim measures which can be granted to a party before or during the arbitral proceeding or at any time after making of the arbitral award, but before it is enforced in accordance with Section 36 of the Act. The nature of such interim measure which can be granted by the court are clearly set out in clauses such and such of subsection 1. In exercising such jurisdiction, subsection 1 would provide that the court shall have the same power for making orders as it has for the purpose of and in relation to any proceeding before it. However, post the award, this reliefs under subsection such and such can only be granted before the award is enforced in accordance with Section 36. In this context, the legislative scheme under the amended provision of Section 36 of the Act, which provides for enforcement of an award, is required to be noted. Section 36 provides that when the time for making an application to set aside the arbitral award under Section 34 has expired, then subject to the provisions of subsection 2, such award shall be enforced in accordance with the provisions of the Code of Civil Procedure in the same manner as if it was a decree of the court. Subsection 2 of Section 36 provides that when an application to set aside the arbitral award has been filed in the court under Section 34, the filing of such an application shall not by itself render that award unenforceable unless the court grants an order of stay to the operation of the said arbitral award in accordance with the provisions of subsection 3 on a separate application made for the purpose. Subsection 3 categorically provides that upon filing of an application under subsection 2 for stay of operation of the arbitral award, the court may, etc. Then kindly come to 27. Thus, for a cumulative reading of the amended provision of subsection 9 and section 36, it is quite clear that the jurisdiction of the court can be called upon to be exercised under Section 9 of the Act by an arbitrator only in the circumstances subsection 1 of Section 9 would postulate. In the present case, on the filing of an application under Section 34 of the Award Act challenging the arbitral award, there was no stay to the execution of the award. HAL was in fact pursuing the execution proceeding. Thus, the obvious consequences was that once the award had become enforceable, the only remedy available to the arbitrator was to execute the award, and a recourse to Section 9 of the Act was not. This is clearly derived from a plain reading of Section 36 of the Act as it stands after the amendment, when it clearly provides that there would not be any automatic stay of the award on mere filing of Section 34. A party seeking a stay of the award would be required to file a separate application as provided under subsection 2 of section 36. Such application would fall for adjudication of the court, and the court, in the facts of the case, would exercise its jurisdiction to stay the operation of the award for the reasons to be recorded in writing and subject to such terms and conditions as it may think fit. Then kindly come to 28. The jurisdiction under section 9 and section 36(2), in my opinion, is quite compartmentalized. And there cannot be any intermixing of the jurisdictions when the court is considering either section 9 application or section 36(2) application. In other words, the provisions of section 9 cannot take away as to what section 36(1) would provide for the enforcement of the award when it comes to exercise of jurisdiction by the court post award. As to whether it would be appropriate for a court to pass interim order under section 9 after award has become enforceable was subject matter of consideration in the decision as referred to by Mr. So-and-so. In the present context, he has rightly relied on the decision of the single judge of the court in data so-and-so, wherein the court has held that the power under section 9 in all its force must be available to the extent applicable till the award becomes enforceable, and after the award has become enforceable, the provisions of Order 21 of the Civil Procedure Code would become applicable. As the award becomes a decree and can be executed as a decree, the court in paragraph 11 observed thus. We then come to the second contention as to whether, after the award has been passed, the power of this court to grant interim relief insofar as section 9 is concerned is limited. That the court has power to grant interim relief under section 9 before the award becomes enforceable is no longer an issue. In Sundaram Finance, the argument is canvassed on behalf of the respondent considering the various expressions used in the various clauses of section 9 of the Act of 96. It will be very difficult for the court on first principle to accept that the powers of the court to grant interim relief are wider than an award is passed, are wider before an award is passed than that after the passing of an award. On the contrary, after the award is passed, the right of the party to an extent is crystallized. For example, in the case of damages, if earlier it is not paid, after the award it becomes crystallized subject to enforcement. All that section 32 of the Act contemplates is the manner in which proceedings come to an end. It does not mean that when proceedings come to an end, there is automatically a decree. The Act itself provides for a challenge under section 36, 34 of the correction, 34 of a correction under section 33. This is now on the question of election. They cannot say that yes, it is an award, and make an application under section. Their section 9 application is not on the basis, if your lordship, I can show your lordship the section 9 application. It's not on the basis that the award is pending, it's yet to be executed, so section 9. That is not the application. Now, on doctrine of election, may I rely on the judgments? Reported in first one is reported in 2011, 1 Supreme Court cases, page 425. Come to paragraph 11 and 12. In Auden Gosai, this court observed as under, law does not permit a person to both appropriate and reprove. The principle is based on the doctrine of election, which postulates that no party can accept and reject the same instrument, and that a person cannot say at one time that a transaction is valid and thereby obtain some advantage to which he could not be entitled on the footing that it is valid and then turn around and say it is void for the purpose of securing some other advantage. The doctrine of election is based on the rule of estoppel, the principle that one cannot appropriate and reprobate inheres in it. The doctrine of estoppel by election is one of the cases of estoppel in res or equitable estoppel, which is a rule in equity. By that law, a person may be precluded by his action or conduct or silence when it is his duty to speak from asserting a right which he otherwise would have had. Taking inconsistent plea by a party makes its conduct far from satisfactory. Further, the party should not blow hot and cold by taking inconsistent stand and prolong proceedings unnecessarily. Well, references are given. And the next one is reported in 2014. 2014, volume 15, Supreme Court cases, at page 144. Can we come to paragraph 22, 22 to 26? Yes. The doctrine of appropriate and reprobate is only a species of estoppel. It implies only to the conduct of parties. As in the case of estoppel, it cannot operate against the provisions of statute. It is settled proposition of law that once an order has been passed, it is complied with, accepted by the other party and derived the benefit out of it. He cannot challenge it on any ground. Then Arlen Musa, etc., Ballard has relied on. Then paragraph 24, the court in Mahuda versus Indrupal said, in paragraph 8, held, the doctrine of election is based on the rule of estoppel, the principle that one cannot appropriate and reprobate inheres in it. The doctrine of estoppel by election is one of the species of estoppel or equitable estoppel, which is then 25. The Supreme Court in Rajasthan State, etc.
The compilation of the different phrases which are synonymous. Hot and cold, fast and loose is an addition. And appropriate. Judgments become like memory games, which I often say. I say one, you say 1, 2. I again say 1, 2, 3, and I add something. The last judgment includes the entire numerals.
One way this helps, I would say that
it definitely helps to know the whatever is the. But just see the Privy Council judgments, Mr. Mitra. This is the settled law, that is the settled. So you did not cite any judgment for
26, it is evident that the doctrine of election is based on the rule of estoppel and as held by
absolutely.
So, the principle that one cannot appropriate and reprobate is inherently the doctrine of estoppel by election is one among the species of estoppel. This is the
Yes.
Governor, I have thought we have craved leave to refer to the SLP. Similar pressure.
Okay.
When we come to page the old melody, it starts from 33, but kindly come to page 57. Interim release, paragraph 8. Kindly come to page 61, prayer 4. Kindly look at this prayer. This was affirmed on ballot appears to be on 22nd September 2020.
What is the page number of the section 9 application in their application, present application?
This one at page 52. It starts at page 52.
Thank you. In the section 9 application, what stand have they taken?
I will show you, Lordship, but before that matter,
Yes, yes.
kindly come to, well, I should show you, Lordship, this stand, but kindly come to page 65 once, my Lord, the praise.
No. Yes.
Both prayers they end.
Yes.
Combined and melody in the SLP as prayer. Now kindly come to the section 9 application melody. Kindly come to paragraph 6.
Yes. Yes. Specifically.
The whole difficulty, my lord, I will tell your lordship, which I face is that this scanning and scanned copies, it becomes extremely difficult, my lord, to read occasionally. Like here, my lord, I cannot read. The proceeding in question were conciliation measure proceedings commenced at the instance of both so and so group and so and so group, which ultimately resulted, conciliation mediation, which ultimately resulted in a settlement agreement dated 10 September 2024 having the force of an arbitral award. In the facts and circumstances as truly and correctly stated therein, the petitioner sought execution of the same settlement award as an award, settlement agreement as an award in EC number such and such. And execution again. I was trying to read out the prayers in execution. Your lordships have followed the tabular statement, all the prayers are due,
Yes, yes,
all the prayers.
yes.
Now, on merit, my lord, kindly come to page 60. Yes. Paragraph 10. Subsequent to the passing of the order dated 20th May 2025, impugned in APOT number such and such, EPI Group has, without transferring the land in question to ASA Group, threatened to prevent ASA Group from using the tanks that were being used and are being continued to be used for the purpose of storing the petroleum products and spirits of Total and Super Spirit. This will be evident from the communication exchange between the parties which are annexed here to collectively work as annexation. Now kindly come to
Sir, it will just come back in 10 minutes.
I was showing this section 9.
Yes, you are going to refer to the annexures which have been referred in
Yes,
paragraph.
paragraph 10. Now, my lord, kindly come to my lord 296, my lord. Section 296. Oh, volume 3. Sorry.
Yes. This is a part of that, the correspondence,
Yes.
Annex D.
Appears to be, my lord.
Yes.
Now, kindly come to 294. Total is writing.
Hmm.
Dear so and so, the timeline shared of 30th June to vacate the tanks is too short, as we have already lined up imports at such and such till December 2025, and the shifting process in our SAP needs to follow a certain process as it is globally controlled. Hence, I request you to please put it up to the board for an extension of the contract till 31st December 25, so that we can have uninterrupted operation. Ideally, we would like to have this extension till such and such.
Mhm.
Then, my lord, kindly come to so this is 27th May, no, 29th May. Now, before that, my lord, this is a trading mail, my lord, kindly come to page 296 at the top, my lord. After this, truly yours, etc. On 27th May 2025 at 1616 Mihir Bodo Tripathi
Yes.
Road. We regret to inform you that we are unable to renew the contract and our position on this matter remains unchanged. We kindly request you to remove all your stored material from our premises by 30th June. In response to that, it appears, my lord, the letter at page 290 on the mail. Now kindly come to 327. Kindly come to page 327.
Yes.
At the bottom, kindly come to my lord after this Mihir border, etc. On 2nd May, on Monday, 2nd June 2025, 11:30 a.m.
Yes.
Ocean of total rights. Dear Mihirji, requesting extension at least till 31st August 2025. Kindly confirm so that I will share the extension letter accordingly. Then, my lord, the response to it is just above that. From Mihir Bodol. Dear Roshinji, we have approached our board and in keeping with good business ethics, they have approved an extension of the last valid agreement until 31st August 2025 as requested by you.
They are seeking extension.
Total was seeking extension. Their case is, my lord, that we are trying to, my lord, disrupt this agreement with Total. The short extension, and that was granted. Short extension till 31st of August, and that was granted. Here. Now, but kindly come to my lord 312. At the bottom, my lord, the letter of 2nd June I have just now placed. From my lord Mihir Board. Just above that, kindly see Alok Sharaf. Dear Roshin, we went to consult on the wording of this letter. What happened? They are aware of it. They are aware of the fact that my lord extension was sought for till 31st August and extension was granted till 31st. Oh. Kindly once come back to 326. In 26, my lord, towards the bottom, lordships will find Alok Saraf is writing on 2nd June 2025
Yes.
at 2:18 p.m. Total sent a request to Hindustan for extension till August without finalizing the wording with me despite having agreed to do so on Friday. See their email below and my reply. Then my lord Oshin of Total response at 4:11 p.m. on the same day. Dear B, thank you for your email. We will start sending our consignment to HSCCL, which are currently at Boswaj. I will shortlist in the extension letter for the purchasing. And Total vacated on 10th of September before the interim order was.
Yes.
Now, my lord, kindly once come back to the judgment, my lord, the division will judgment.
Of the Bombay?
The Bombay.
Yes.
My lord, towards the bottom of my lord, paragraph 14, my lord, at page 9. Towards the middle of that, my lord, paragraph 14 at page 9.
Yes.
The sentence starting with the second facet of section.
Second facet, yes.
This second facet of section 9 is the proximate nexus between the orders that are sought and the arbitral proceedings. When an interim measure of protection is sought before or during arbitral proceedings, such a measure is a step in aid to the protection of the arbitral proceeding. When sought after an arbitral award is made, but before it is enforced, the measure of protection is intended to safeguard the fruit of the proceedings until the eventual enforcement of the award. So, my lord, section 9 grant protection till my lord the award is finally enforced. That is, my lord, what is, my lord, contemplated. Here again, the measure of protection is a step in aid of enforcement. In aid of enforcement. It is intended to ensure that enforcement of the award results in a realizable claim and that the award is not rendered illusory by dealing that would put the subject of the award beyond the pale of enforcement. Now, it is in this background that it is necessary for the court to impart a purposive interpretation to the meaning of the expression at any time after making of the arbitral award, but before it is enforced in accordance with section 36. Under section 36, an arbitral award can be enforced under the Code of Civil Procedure in the same manner as if it were a decree of the court. The arbitral award can be enforced where the time for making an application to set aside the arbitral award under section 34 has expired, or in the event of such an application having been made, it has been refused. The enforcement of an award ensures to the benefit of the party who has secured an award in the arbitral proceeding. That is why the enforceability of an award under section 36 is juxtaposed in the context of two time frames. The first being when the application for setting aside an arbitral award has expired, and the second where an application for setting aside an arbitral award was made but was refused. The enforceability of an award, in other words, is defined with reference to the failure of the other side to file an application for setting aside the award within the stipulated time limit, or having filed such an application has failed to establish a case for setting aside the arbitral award. Once the challenge to the arbitral award has either failed under Section 34 having been made within the stipulated period, or when no application for setting aside the arbitral award has been made within time, the arbitral award becomes enforceable at the behest of the party for whose benefit the award inures. Contextually, therefore, the scheme of Section 9 postulates an application for the grant of an interim measure of protection after the making of an arbitral award and before it is enforced for the benefit of the party. Which seeks enforcement of the award? Which seeks enforcement?
Mr. Mitra, if the legislature wanted in section 9, it could very well put in this expression: a party may before or during arbitral proceedings or at any time after making of the arbitral award. But before it becomes enforceable in accordance with law. That could have been used. Why before it is enforced?
Before it is enforced, kindly content.
That is the contribution of the learned single judge also.
I'll ask. Today, my lord, an award is made.
Yes.
My lord, the time expires, my lord, to my lord make an application for setting aside. My lord, the time expires.
Yes.
It expires today. The award is made before the time, my lord, expires today. The award holder can, my lord, start execution tomorrow, or my lord, it can, my lord, put the award in execution after, my lord, a month. In the meantime, he can make an application under section 9
Yes.
before it is enforced.
But as per the Bombay High Court which you placed before us,
Yes.
the learned single judge relied on a division bench judgment which says otherwise. The moment it becomes enforceable, no section 9. Compartmentalized.
But according to me, my lord, my interpretation or my reading, my lord, is that, my lord, it can be otherwise, my lord, it becomes extremely difficult. I put the award, my lord, into execution after a month. I can still seek relief, my lord, in the meantime.
Yes. Because why our context is wider. The canvas which we are looking at,
Yes.
Mr. Mitra, is there are 3 steps in section 9.
Yes.
The first step is before any arbitration proceeding is initiated.
Yes.
There it is unfettered, governed only circumscribed by the parameters of section 9 itself.
Yes.
So unfettered in a sense. When section 17, the arbitration proceeding starts, then section 17 intervenes. Therefore, no exercise of section 9. But even then, Mr. Mitra, window has been kept open. Suppose the arbitrator is not sitting or some situation like that. So therefore, it's not an absolute bar. Section 17 is not an absolute bar. Some window has been kept. Similarly, after the award is passed, again there is a background. I mean, during pendency of the arbitral proceeding, that is the stage where there is a direct overlap between 17 and 9. Despite that, a small window has been kept if 17 cannot be in go. But then why should it look at it differently after the award is passed? Because then also it's all the more necessary to protect the fruit of the award. Before the arbitration proceeding started, Mr. Mitra, it was only an inchoate thing.
Yes.
I mean, even that is protected.
Yes.
But why should not all the more the enforcement itself, the fruition of the award be protected by section 9?
Yes.
Yes, you are right. Section 36(2) gives a limited power of stay of operation. But that is, section 9 is like injunction, receiver, all read into one. Attachment before judgment, order 38, order 39, order 40. All 3 combined into one is section 9, basically. But why shouldn't that be applicable during the proceedings also? I mean, isn't it counterintuitive?
My lord, in that event,
Yes. We could, sorry, just before you start, we could appreciate if section 36 court had equivalent powers. But section 5 of the Arbitration and Conciliation Act says, unless specifically given, no judicial interference. Section 36 is very specific, does not speak about anything like section 9. So there will be no remedy till the fruition. That is what is
my lord,
disturbing us.
in that event, my lord, an award holder
Yes.
would be entitled to, my lord, apply under section 9 as well as, my lord, in execution simultaneously.
Yes. Yes. We are saying yes, we are going to that extent because section 36, I am entitled. 36(2) is for the other side to say. The space not for the our debtor.
Yes.
So 36 code, whatever is available for execution, enforcement of an award in the in order 21 in CPC will be applicable, but nothing further. Does not operate as a civil court otherwise. Only the proceedings, only the procedural modalities of execution as governed by the CPC would apply. But then the executing court is a toothless tiger, on paper tiger. It would be an absurd proposition, Mr. Mitro, to say that before I initiate an arbitral proceeding, I have a right of protection.
Yes.
But after I get an award,
Yes.
nothing provided in section
I
5.
do not say that.
So what would be the provision under which there is no section 17 anymore?
It's not required. Till ballot, as I have submitted.
Under what provision?
As I have submitted ballot, till ballot it is put into execution. Section 9.
No, the day it is put into execution and before the award is satisfied. In the interregnum, during pendency of the enforcement proceeding.
Execution. Executing court.
What powers does the executive court have as under
Only
section
powers.
36? Under which provision of law, Mr. Mitro?
36 read with ballot the civil procedure. The civil procedural court ballot for execution has been ballot engrafted ballot in section 36.
There, with due respect, Mr.
The
Mitro,
ballot in that event ballot.
97 to 101 logic comes in. It has not been engrafted. It has not been bodily lifted. The language used is the provisions of enforcement in just see section 36. Because otherwise 2197 to 101 will come in. Everything will go. The entire hierarchy will be shattered. Such awards shall be enforced in accordance with the provisions of
It is
the
according to the provision.
enforcement is in accordance.
Absolutely.
Order 21 to 32 and the other provisions.
Whatever it is.
But there is no power conferred on the executive court to pass any order akin to either section 9 or section 17. And you have to keep in mind, Mr. Mitro, also that the court which entertains an application under section 36 is the same court which entertains section 9. The level is the same. You have to keep that in mind. The level is the same. Therefore, simultaneously, why should section 36 and section 9 not be maintainable? What is the bar? It's a mindset problem of us. And where is the bar? The court is the same, not a superior court or an inferior court. The arbitrator has section 17, protection given. Before that, section 9, protection given. After I get the award, I don't have any protection until it is executed. Section 36 that does not empower the court to pass it.
In that event, my lord, kindly come to section 9. My lord, in that event, my lord, this court has to hold, my lord, the reliefs which can be granted by the court under section 9 cannot be granted by the executive.
Yes, we have to hold that. We have to hold that. Cannot be granted by the executive. It's counterintuitive, but that's there in the provision. Show us the power and we'll hold otherwise.
But kindly once.
It's counterintuitive, we are saying, because Mr. Mitru, we are so accustomed to order 21. We are so accustomed to order 21. A civil court is at the end of the day civil court and doing it. But here civil court is an authority under this act, acting as a civil court.
But kindly once come to section 9.
Yes. But otherwise we'll have to say then order 39 will apply to an executive court, although it's not applicable otherwise. Order 39 applies. We'll record your argument on that, Mr. Order 39 applies in and section 36 proceeding.
In execution.
If order 39 applies, why shouldn't section 9? Section 9 is in the statute.
Section 9, yes. You can make an application under section 9. According to me, till my lord, the award is put into execution.
No, we are speaking only of the zone when it has been put into execution but not yet executed. During then, what will be the protection?
Kindly once come to section 9. Section 9, kindly once come to section 9.
Yes, Mr. Mitra.
Interim measures, etc. by court. Interim measures. A party may, before or during arbitral proceedings or at any time after making of the arbitral award, but before it is enforced in accordance with section 36. Not minor does not say, the legislature could have said before it is finally enforced or completely enforced.
Enforced means finally. It's like saying, I mean, passing a final degree or finally satisfying the degree. If a degree is satisfied, that's final. If a degree is passed, that's final. We need not use the word final. Enforced is final. But it's the other way around which we are contemplating, subject to what you say, that it would be, if it was meant otherwise, that but before it becomes enforceable. Because becomes enforceable is within the purview of section 36 itself. Because section 36 says, where the time for making an application to set aside the arbitral award under section 34 has expired, then such award shall be enforced in accordance with the provisions of the CPC. Therefore, it's within the contemplation of legislation and it uses where it wants to use that after this time the appealability has expired, then it can be enforced. Now, then the window for enforcement becomes open. Before that, it's closed. You cannot enforce, even if you like, before the appeal period is over. It's a negative clause, in fact, that you cannot even put it into execution. Enforcement application cannot be filed, Mr. Mitra, before the appeal period is over.
So, my lord, in section, may I, my lord?
No, we are. This is the discussion.
In execution,
Yes.
an award holder cannot seek for an interim measure of protection in respect of preservation, interim custody, all this.
Give us a provision, we'll say yes. In this act. Give us one provision. Because specific provision had to be made under section 9. Specific provision had to be made under section 17 to empower the arbitrator and the court respectively. Apart from section 9, there is no provision akin to that. But section 17.
So,
Apart from section 9, there is no provision in the statute, entire statute, which empowers, gives such power. Now, executing court, Mr. Mitra, executing court has powers. But when executing court exercises such powers in a civil suit, then that power is under 151, not under Order 39. Because Order 39, Rule 1 and 2 contemplates in a suit. Therefore, it's ex debito justitiae. Civil court inherently has power. Section 151 recognizes the inherent power. Not that section 151 confers power. That has been discussed in many judgments. That it's the inherent power of a civil court, not conferred by section 151, but recognized by section 151. Under that, it can do it. But here, the definition of court is very restrictive. Principal court of original jurisdiction, it has the power because this act gives it the power. Not because it's a court, not because it's a court under the Bengal Agrasam Act or some other act. Because this court, if this act said, Mr. Mitra, not principal civil court of jurisdiction, but the chief metropolitan magistrate would do it, then it would be the chief metropolitan magistrate, which did not have this inherent power. Therefore, powers exercised under this act are entirely within the confines of this act, which logic is strengthened by section 5 of the act itself. And CPC is not applicable otherwise as per section 9. Therefore, Mr. Mitra, if you read section 19 probably in conjunction with this, because section 19 says, 1 says, the arbitral tribunal shall, that is the arbitral tribunal though, not the courts, but arbitrators shall not be bound by civil procedure code. If you read that with section 36, only the powers of enforcement given in the civil procedure code will apply, not the other provisions in section in order 21. And order 21 does not have independently any power of grant of injunction also. Order 21 of the CPC does not have any power engrafted in it, like order 39. There is no such power in order 21 itself. So what does the court derive the power from? It's not a civil court in the usual sense. That is the difficulty. If you say section 9 is not applicable during the pendency of the 36 proceedings, 36 court acts within the parameters of section 36 and can grant a stay of operation to the judgment debtor.
That's valid.
Yeah, obviously.
That's true valid, yes.
But apart from section 9, we don't find any other provision, Mr. Mitra. If we shut out section 9 and compartmentalize it, as Justice Kulkarni has said, then we don't have any other provision for the executive court to pass orders in aid of.
Kindly give me a taste. Valid. This is valid, a point valid, which would have valid
Repercussions. Very. So, anything else you want to point out, or merits you had pointed out?
This is the point.
So, on this, we'll come back on the next one. Despite what you learned to me, we'll discuss only this point on the next, and then go to whatever you have to. Anything else you have to say, you say today. Just exhaust their energy and then come back on the next day only on this point.
The next day would be 21st perhaps.
Yes, 21st.
21st one is at the beginning of the year. Then 28th one is
28, because we want to make it continuous. Mr. Mitra will submit and then we'll finish.
28th.
28th, unless Mr. Mitra has any difficulty on 28th. Harding part. Let the matter be listed for further hearing on January 21, 2026.
28th.
January 28, 2026. Sorry. What else should we have to do?
I would.
Thank you.
Number 3 and 4.
Yes.
Yes, for the judgment of item. The last commission, the applicant began with their argument.
Yes. Please appeal for them. You are appealing.
This is your action.
Mr. Abhijit.
Yes.
Please make it not to the first second. On the prayer of the appellant, is it an appeal?
Yes.
On the prayer of the appellant, the matter is adjourned. Adjourned for the day means adjourned for the day.
Number 5 and 6.
Mr. Rai is saying something. Mr. Rai was in this matter also.
Yes. He's for one response for the council, for the council matter.
Mr. Rai, we are adjourning it for the day.
But I thought Mr. Mitra is not finished.
He has not.
You are right in thinking that.
Well, that's why I thought after Mr. Mitra, Mr. Mojumdar, and then I was supposed to start my because that is what we followed on the last occasion.
Yes, exactly. We stick to that.
Fine.
Coming.
Yes, sir.
Then let us
Mukherjee is in NCA. He's the one with the liquid text he has been. It's only half an hour. I know. Okay, just yes. Well, let me do.
Oh, yeah. You're almost concluded, Mr. Mitra.
I have lost track of what, because there's so much gap. 2 months, every 2 months I'm getting a chance.
But every time it will, we'll put it in a written notes of argument and we'll just.
What I will do is,
Otherwise, every time it will restart and restart.
I will come with a
It will never, it will be a never ending process.
prostitute, then will also make an order, because then also with the written notes shall come. And I shall summarize my submission next day. And so that I also have satisfaction of just putting my case with the.
No, Mr. Mitra, you start today. Make your submission. You are not
And
restricting it.
next day I will come with my written notes so that
We'll put it in our order today. Just remind us when we end. But the other side then.
I will give my copy. I have no such thing, because I let them also know, since it's a
If something new comes up in their.
well,
If something new comes up in their
I will
argument.
give a fresh note or a supplementary. And this is, since it's a case of re-argument,
Yes.
really. So if they can also give their note, so that we can all.
Before the next date, you can exchange your notes and come back with. You will get a structure of the arguments and we'll also.
Can I just today cover Mr. Anirban's argument on the Anirban's argument on this on the chartered accountants regulations, because just to go back to where we whether this is on the issue of whether the partnership deed, the earlier partnership deed of the year 2001 and so there are two partnership deeds in question, exact dates.
Very well. Two.
One is the 14 partnership.
Yes.
14 partners partnership deed is the admitted one,
Yes.
and the 3 partners deed is what they are seeking. A photocopy is what they are relying upon to subsequent deed, which they are saying is inconsistent with my return filed with the institute under Form 18. Now they are so I made a misstatement before the institute. That is the case.
14 partners deed is admitted by. I mean, you are relying on that.
I am relying on that, and I have said there is no such thing as a 3-partner deed.
Right.
14 partners deed with 3 partners are profit sharing and 11 are non-profit sharing, as is mentioned in our Form 18. Now, though the findings are, of course, on charge 1 and 4, that I have not misled the institute.
Yes.
Which is the necessary criteria for a conviction of a misconduct on my part under Schedule 1, which is within the domain of the council. Otherwise, it has to be transferred to the High Court. So we had shown the 2001 partnership deed, original, to the members of the disciplinary committee, because as per the institute's regulations, the deed need not be uploaded in the system, in there, or just filed with them with the solicitor. It has to be given, names have to be given, and it has to be said how many are whether they are profit sharing or non-profit sharing, or there are some non-profit sharing partners that there. That's all. So, whether we the disciplinary proceeding, we had shown the partnership deed to the members. This is recorded in 2-3 places, and we were not keen on the complainants having a look at it, because that as a member they are not entitled to, and because of the
Ongoing
dispute and everything except that, this will go to somebody else who is the main brain. I mean the brain point where through which what they will start, where this is very difficult to happen. So we had showed it a couple of times, and we had said, take a look, and if you want, we can formally submit to you, but in a seat cover on the members took a look and gave it back to us. At the final stage, though it has been held that I am not misled, but there is a finding in 2 places. Different. One place it has never been disclosed. Another place it has been disclosed, but taken back. Now, And there's also a finding, since I did not give it to them, I will not look at it. 4, of course, are not relied upon because 4 original they couldn't produce. And now, for that I had shown that it is adverse. This is not adversarial procedure. That is there are 3 stages. First, at the counsel stage, when the complaint is made, the written statement, rejoinder, all the pleadings exchanged. Counsel forms a prima facie opinion that they should be referred to the disciplinary committee. Before the disciplinary committee, it is not adversarial anymore. It is like criminal case between the disciplinary between the institute versus the accused member. And also all the counsel the same. So my non-disclosure to them cannot be a relevant factor. For that, I had shown the section, that is section section hearing will be on yes, 20.
12.
Section 20.
This is not the regulations. The regulations.
So the act first. First the act. The act, firstly, I placed that section. What should recall factor is higher than mine.
No, not our recall factor, our tax factor.
The Lordship will possibly be able to help me a bit on that score.
Section 21 you are.
Yes, 21, that to show that it is not adversarial.
Yes.
21 subsection. Where the misconduct in respect of which the council has found any member guilty other law. That is why it is referred to in the High Court. Now,
There is no scope of giving any opportunity to the anybody. No, the respondents here, they claim to be the complainants.
Complaint. Apart from one respondent, who is the institute.
Yes, institute is.
Now, that becomes, yes, also can you see 21.4, where the finding is that
The member and opportunity.
now they had relied upon the regulations, Mr. Hon'BLE,
Yes.
in his replies in submission, now since I'm dealing with it once for all, but he had relied upon the CA regulation
8, 12, 12, 8.
12, regulation 12,
8 says on receipt of the statement, if any, the secretary shall send a copy thereof to the complainant.
That is the first stage. That is in the first stage. It is at the first stage. That is the complainant. That is it is sent to the complaint. Now, he had relied upon regulation 12. 12. But 12 applicable to a complaint or information pending before the council or any inquiry initiated appeal made to High Court prior to not important. 12 subsection 12 subregulation 3. Such complaint shall contain the following particulars, namely the acts and omissions which you prove defendant. B. Oral and documentary evidence relied upon in support of the allegations made in the complaint. Now, Lordship, kindly come to regulation 6. Ordinarily, within 60 days of the receipt of the complaint, under section 21, the secretary shall, if the complaint is against a member, send a copy thereof
to such member at his professional level. If the complaint is against a firm, send a copy. Now this takes us to sub-regulation 7. A member against whom the complaint is made may within 14 days of the service of a copy of a complaint under sub-regulation 6 or within such time as may be extended by the secretary forwarded to the secretary in triplicate a written statement in its details verified in the same manner as the complaint. Now, 8 is what they were relying on.
8 and 10.
8 and on receipt of the written statement, if any of the narrations send a copy to go over the and the complaint will be made within 14 days of service. Now, this is at the section 21 once 8, 9, 10. This will become clear from 11. 11, if you see, that is 21, 1 and 11 together. If on a perusal of the complaint, the written statement, if any, the complainant rejoinder to the written statement and the respondent's comments on the complaint rejoinder, if any, and other relevant documents, the counsel is prima facie of the opinion and the respondent is guilty of professional and other misconduct, the counsel shall call an inquiry. This is 21. That's the first thing. If on the other hand, it is not the first 21 months, because that is the counsel. Now, we are concerned with discipline. Now, Lordship,
That procedure is provided in regulation 1512.
15 is the post formation prima facie. That is 21, 1, second part. Shall refer to the disciplinary committee. And disciplinary committee, I am reading for 21, 1. And the disciplinary committee shall thereupon hold such inquiry in such manner as may be prescribed. Now, that prescription is 15. If you read 15.1, it shall be the duty of the secretary to place before the disciplinary committee all the facts.
Only 3.
The respondent shall have a right to defend himself before the respondent.
None else.
And just in case, though they did not go this far at all, just in case Lordship afterwards sees to carry out cover 15.5.
Yes.
With the word party.
Binding will be communicated.
Where during the course of an inquiry there occurs a change in the membership of the disciplinary committee for any reason whatsoever, any party to the inquiry may demand. Any party would mean
This you are reading from
15.5.
15.5.
15.5. Where during the course of an inquiry, that's more than the disciplinary committee, there occurs a change in the membership of I'm calling it DC. For any reason whatsoever, any party to the inquiry may demand that inquiry be held. By any party, it is 15.1 or 15.3. That is the
Institute or the accused. Yes, of course. But then why should the DC itself, on a change of membership, demand
not DC itself, one of the parties. Like I may say,
for the institute, sorry, not the DC. Right.
Institute or the
All right.
Now, Lordship also sees 16.
Yes.
16 is at the 21 4 stage. The committee shall submit its report to the council. Now, where the finding of the disciplinary committee is that the respondent is guilty of professional and or other misconduct. A copy of the report of the DC shall be furnished to the respondent and he shall be given an opportunity. So even before the council only the then I shall now seeing this we had not noticed. I will make an additional point that the disciplinary committee and council wrongly tried to turn into the adversarial proceeding by calling the complainant even before the council. Disciplinary committee, they were there throughout, they were allowed to participate and everything was. Then 16.3, the same thing. The council shall consider the report of the DC along with the representation in writing of the respondent, if any, and further inquiries said council. So, by not giving a copy to the or not sharing the
They should not have been involved at all.
involved at all.
That is right.
And not considering the 21. Yes, and then also might be writing about the 16.5. Finding of the council shall
16.5. It will only communicate. Post-facto communication. Right. Is there a provision of any appeal against this?
No, not from. Because this institute is from institute the because if the institute found, if the council found the second schedule, then it will be referred to that. And there is a statutory appeal. I think the High Court is a statutory appeal. Or appeal 22A. Any member of the institute agreed by any order of the council imposing on him any of the
22A, section 22A.
22 capital.
Yes. Any member of the institute.
Appeal to.
So it's like a contempt appeal.
This is like a statutory appeal,
like a contempt appeal in the sense only if penalties imposed, the person on whom the penalties imposed can be punished. None else.
But additional ground because
We said we look into the appellate provision to assess the scope of opportunity to be given to the complainant also. Then we have to look at that also. So prejudice test also comes in.
only I
So they won't be prejudiced because they don't have a right of appeal.
Lordship, the judgments which they had, well, I had relied upon the judgments which we had cited earlier on the point that if mens rea is required to be established, then there has to be clear finding. Not that where is the report of the not that it could go either ways. Just take out the
Right of the victim even was very limited till recently. So here complainant is not a victim, need not be a victim.
it is the other way now. In the criminal procedure code, the victim's rights are
And if it's an offence against the state, victim's rights were originally not much. Victim's right of appeal was limited. Now it has been enlarged.
even the choice of investigating agents.
Some yes.
I have done a few here.
No, same here.
Lordship may have taken a criminal bench. At the bar, Lordship knowledge was similar to mine.
Less than. But Mr. Mitra, that is why here a complainant is only the initiator of the entire.
like it is criminal case.
Therefore, before forming a prima facie opinion, he have to be heard. To form a prima facie opinion, what is his complaint? The scope of his complaint. Where will you get the point?
That is in addition to the criminal and the criminal will make the complaint and then it gets
Right.
But then now so The finding that can't be relied upon because I did not give a copy to the other side. That is that could now I shall come. Well, there were judgments which we had cited for different propositions for the there has to be a finding that I have been guilty of it. Now I had relied upon 2010 9 SCC. Copy of it.
Yes, yes. Give
10
it.
9 SCC,
Yes,
page 630,
there are 35 to 38.
paragraph. That's the finding. And here the finding is at page 546 for charge 1. Paragraph 54.13.
54.13.
That is the disciplinary committee's findings on charge 1,
This is page 5.
46. 546 and 551. These are the two findings on charge 1 and charge 4.
So there is nothing relating to menstrual.
No, in fact, if I may be reading out, in view of the above, the committee wishes to point that the respondents have either filed false particulars with the institute and impaneling authority or furnished false particulars with the tax authorities to claim salary of partners and expenses and to save tax. This is an act which is unbecoming of the tax. Accordingly, the committee is of the opinion that they are guilty of professional misconduct falling under clause 1, part 3. There is no finding that I have filed false particulars with this. And for the same charge, because the allegations are the same, under charge 4, there the finding is that I filed these documents at page 551, paragraph 63.1. Admittedly, the respondents and their firms have filed same particulars with the impaneling authorities which they have filed with the institute information. In view of the finding, the committee is of the opinion that the respondents have filed false particulars with the impaneling authorities too. There is no finding of furnishing false particulars with this. The charging section is only clean. That whole and not relying upon the partnership deed. One place, of course, that we are not using. Other is 54.7 at page 544. It is neither possible nor justified to place reliance on the documents shown to the disciplinary committee by the respondent during the course of the proceeding. None of such documents or copy thereof were filed either before the council or the committee. Neither any opportunity, because that is fine, that is because they should. Neither any opportunity was given to the complainants to offer their arguments on such documents. That is going beyond the statute, act, and the regulation. While at the same time, at page 539, 531, paragraph 45 towards the end, it is recorded. During the proceeding, the respondents have shown the original copy of partnership deed to the disciplinary committee only and refused to file the same or copy thereof, looking into the intention and motive behind the complaint filed by the company. There again, I had shown that we had said that we are willing to give it to the submit to the institute, but not that we are willing to submit it in the recorded by writing that so long as it is not disclosed to the complainant. By letter we had disclosed that. We had even record.
Page 267.
Yeah, taken out. Yes, no, this is 7:47:38. 7:38. 7:38. The advocate's letter. Which is 7:30. At 7:41. My clients are, after explaining why it shouldn't be given to the other side, my clients are ready and willing to submit a copy of the partnership to the DC. The original whereof was produced and shown to the disciplinary committee and recorded at page 78. It called upon to. And so far as this now, though that's really not germane, considering that schedule 1, it is misleading. So far as the other authorities, any income tax and all that referred to, it is on record the income tax assessment order when the assessment was reopened, and all those expenses which were deducted as salary to the partners, non-profit sharing partners, has been added back, and I have to pay the tax. The revised assessment order is at page 667. The revised assessment. And they have also lodged complaints like to everybody to go to the income tax, the empaneling authorities like the comptroller and auditor general and the reserve bank for bank audit. And that's also part of the deposition. In the transcript it is there. And they have no one has found me guilty of it. So no one, so the reckless finding that I may have misled the empaneling authorities, firstly, completely beyond their domain. It's for the empaneling authorities to see whether I had misled or not. But that also, there were complaints that no one has found. I will just deal with the judgment cited by the court for the complainants. For the complainants,
Complaints of the institute.
the complainants are the private individuals.
Yes.
Then they are alias.
Yes.
Criminal law parlance, they are de facto complainants.
Right. Yes.
2006 5 SCs. 360.
2006 5.
361. Civil obligation, they're quite big there. 99 goes to 5. Oh, well, this is the institute has to.
Institute, this is institute, yes.
Yes, well, may I just yes.
I have them separately.
Yes, I'm sorry. 2006.
No, sorry, I want to institute. Yes, expect to institute first.
Because there it was expressly said in the section. 2006 5 SCC 361 paragraph.
Para 29, it has been stated found in our opinion, ministry is not an essential ingredient for contravention of the provisions of a civil.
But 28 will occupy.
28 also, yes.
28.
Yes.
Um,
The sections require none.
and that is
Yes.
and if you come to 30, paragraph 35. Section 15.
Yes.
You kindly see the placetum E down. We also further held unless the language of the statute requires the need to establish the premise of wholly unnecessary to ascertain whether such a violation was intentional. On a careful perusal of 15G and 15E, nothing which requires that mens rea must be proved before penalty can be imposed under these provisions. Hence, once the contravention is established, then the penalty is applied. Now, unlike our
This is vis-a-vis part 3, which says knowing them to be false.
knowing them to be partly, but by the law. Knowing them.
But there are other charges also.
We have been charged under part 3, charge 1.
One and the other one.
One for both under part. For both under part 3 charge.
Oh,
Charges, but the penalty, but the misconduct is part 3 charge. Yeah, it's come with no 15 minutes I will take. Okay.
hard part for further hearing on next Wednesday.
Next Wednesday.
On for further hearing, list the matter on January 21, 2026.
Well, there's the next one is the earlier matter also I'm told has been kept next week.
The one matter was kept on 28th.
But
Maybe these matters may abruptly.
I can finish to all
The other matter, Mr. Surajit Nath Mitra's matter. So that will not probably not take much.
Okay.
And the other matter has been fixed on 28th or other.
You want a 1 month gap? Then I will forget what I.
No, the moment you say we recollect.
You recollect that. For me to recollect it's a time.
Yeah. Order for on application don't mention this week, come back next week, we'll take.
All right, application also.
We'll take up next
So
week.
the application for itself of type of handling the guaranteed provide.
We'll take up all applications and order for next week. Yes, correct.
Or the
Correction upon
Item number 1 to 15 for judgment.
all the FFT numbers are given, allowed in part, thereby setting aside the judgment and respective awards. And the same directions are given, exactly identical. That also given, as in the previous.
Item number 16.
Item number 16, I appear for the apple. There is a billing at my instance, my lord. There was a direction to file because my 6 weeks was right. Granted, I am little late in preparing the paper which is very time is already filed, but it has to be extended so that.
Learned counsel for the appellant submits that due to reasons beyond the control of the appellant, the paper books were filed late. Next para, the delay in filing the paper books is condoned and the paper books are hereby accepted.
Item number 17.
You have to file.
That
One indulgence only.
Yes,
I
Mr.
have given a copy of a case which has not been cited to my development. I have requested him to bring. He has assured that he has done.
oh, fantastic! Thank you.
So, Madam, we are seeing in between notes.
Dean,
So, one way judgment of this observation, the point I was trying to have before my lord, that even on, forget all that. If after 18 months it is not possible to remember, on that ground I should score. So that, on that point,
you spoke about this in the passing, but you did not cite it further.
yes, I paid for that. So I thought well, so one page on that score only. That it will be.
Yes, therefore we are setting aside.
This judgment was also considered in
Right. So therefore you have comprehensive.
within one paragraph, do not have.
That's it. Thanks. The written notes of arguments filed by the appellants and the respondent stroke KMDA today be kept on record. Sir. Hearing is concluded and the matter is reserved for that.
Is it for the special leave to be granted to us for the new case?
No.
By an order dated 23rd of December 2025, there is a protective order, which is there till until for 31st or until further order.
The interim order granted earlier stands extended till disposal of them. Right.
Item number 18.
No. We have already exhausted. We can exhaust. Yes, what is the No. Yes, Mr.
Is the appeal whereby the judge has been able to this section 5 application plus and again has been prepared with the court but it's not prepared after the separate to be prepared. That is why I got to some.
Section 5 is there.
Section 5.
Very.
Only plaintiffs respondents of the lazy particular as a
No, not plaintiff.
defendants.
Different. Great.
Yes, so the
Is a misappeal served everything? The appellant has served copies of Can 1 of 2025 as well as Can 2 of 2025 and the memorandum of the appeal on the defendant numbers 6 to 8 stroke respondents and file an affidavit of service to that effect on the returnable date. Push up the applications shall next be listed. The matter shall next be listed under the same heading on February 9, 2026. Push up next para service on the pro forma respondent.
So it is mentioned from 90 onwards, Malad, at why it's Malad?
Service on the respondent numbers.
Seven.
Pro forma respondent numbers 9 to
7 to Malad,
6 to
6.
no, but
6 to 8 up to depending on 6 to 8. This one number 7 is a necessary party, Malad is fine. And from 9 onwards, Malad, the performance.
আচ্ছা তাহলে যেটা আগেরটা বললাম ডিফারেন্ট
Up to 6 Malad certification.
1 to 6
1 to 6. I have to serve 1 to 6.
1 to 6 stroke respondent যেটা বললাম ওই সার্ভিস হবে আর কি তারপর নেক্সট সার্ভিস অন দি respondent numbers 7 and 8 and pro forma respondent numbers 9 to 11 are dispensed with for the present at the risk of the appellant on the prayer of the appellant.
Item number 19.
Going to the management of whether the appeal is maintained or revision is maintained, that is the question. This is the appeal allowed.
7-11 rejected.
Yes. Trial court allows order ruling. Because that appeal has been preferred because it is a allowing of order rule 11. Appeal court.
Mr. Rather, defects have been cured. One is name of respondent number 2 in the certified copy does not tally with the.
Only requirement.
No, that has to go down.
Go down.
A preamble.
That is now I don't go through the
Yes.
preamble because there is divergent view. That is why we are not hospital is the second appeal. Let it place your worship.
Preamble does not mention the name of the.
Oh, yeah.
প্রথমে একটা লাইনে leave is granted to the learned advocate advocate for the appellants to rectify the defect regarding the preamble of the memorandum of appeal during the course of the day. So yes.
It was fine of the section 22 of the Minister for preemptive class. Whether that should be better or not, I'm not going to that. Order 11.5, that was allowed. Against that, an appeal was preferred. Appeal court rejected order 11, practically allowing the suit to be continued with the court. Now, against that one, I filed the appeal. Now, the question court of the appeal is maintainable or revision is maintainable. If the appeal is maintainable, what will be the scope of the appeal? Under order, which should be affirmative or second appeal.
So whether at all an appeal is made.
Yes, that is the precisely. First thing I have to overcome whether the application. This is the larger judgment. Though it is recorded as a concurrent, but subject to pressure on all the judgments doesn't have
Different.
different.
Conclusion was same.
But I join not say answer when can join to this is really
Give a copy to Mr. Mitra.
yes. Equally. But if you look at kind chance, the issue was only for and it is fine.
Yes. Issue where? Yes, that's it.
That's not the issue.
It was the other way around. Here it was the other way around.
Yes.
The National Court rejected the claim.
If you look at kind chance,
That is different from this case.
page 40, paragraph 47. Now I can.
This assistance part. Yes. 47 years. Now this share is.
Oh, so between item 47. Now the issue arises. When the proper elector either affirms the order rejecting the claim or reverse the order.
Samunto, softer. Yes. Yes.
Either affirms the order rejecting the claim or reverse the order, thereby restoring the suit to be tried on merits. What is the remedy available to an aggrieved party? It is in effect an order demand under Order 40/23. An order demanding the suit to be tried on merits is however applicable under Order 43 Rule 1U. the court of procedure and has to be classified as not miscellaneous appeal, but it required to be admitted under substantive proceeding of law under 100 related or whatever level of the court of procedure. But when this was expression was given. Now I can turn to paragraph 67.
Yes.
Is thus follows, my lord.
Yes.
Nature jurisdiction that was represented given predominant importance preference over the nature of the order. The nature of the jurisdiction prevail over the form and spirit of the order. The region of such and such was not considered in Ports International Limited, where it has been decided the revision court is the part of general appellate jurisdiction. And in following the said resolution, such and such, it would held the order allowing, rejecting, or plain should be treated as a deemed degree, and hence the second appeal would be maintainable may not be correct law in view of the latest judgment Ports International. Under such answer reference, it has been said it may be contended that Shankar HON'BLE was rendered in the context of merger order. This has been dealt with by Justice such and such in a separate concurring judgment. Now I can turn to
Under such circumstances, we answer the reference in a negative. In view of paragraph 32, the proper remedy would be to file a writ petition under 227 of the Constitution.
yes.
Against what? If the
reference is given by the revision court. Whether the remedy lies filing if the revision court is of the reverse the finding of
the 227 lies. Who appeared in the matter? You appeared.
No, my lord. Now can cut paragraph 83.
Where is Mr. Shona Bhattacharya? Yes, we'll wait for. And Mr. Mukherjee. Great. Yes.
Now I can turn to 103. The concurrent view of Justice Chandra which has been held, my lord, and turn to paragraph 103.
Yes.
I have the view, my lord, got it.
Yes.
The court rejects an application also given and the revision court reverses the said order by rejecting the claim and applicant to criticism constitutional will lie. But when such an application is allowed by the trial court and in appeal, the appellate court either affirms or reverses the same deemed degree, a second appeal within the scope of 100 will lie. This is once.
We'll say that this part is omitted because of the question posed in the reference.
The implication of this here
Justice Hiranma Bhattacharya?
No, not this is said it is not, it is an obitter, it is not the issue before the special bench and the civil.
Exactly. Thank God he was there.
I mean,
we hold the same view. We hold the same. This is omitted. Beyond the reference.
It is not the reference, the issue which is
exactly. Justice Bhattacharya is absolutely right. And Sri Bhattacharya should concur. This is Hiranma and this is omitted beyond the reference.
No, but if you are logically considered that way, then the appeal to that is
appeal. No, here revision lies.
Their revision lies for rejecting an application or understandable level.
No, here the revisional court has rejected the claim.
No. Yeah, in the larger reach.
No, in your case?
Appeal court rejected the claim.
Appeal court rejected the claim. So obviously it's a decree.
Yeah.
No, the other way you're reversing the situation.
Yes. Trial court rejected.
We are hearing.
Yes. Trial court rejected the claim. Appeal court reversed.
Yes.
And rejected by application or understandable.
Yes, that's a reversible.
But here what it says this.
Here it was the reverse. The reference was reverse.
Reverse was reverse, but it is held that on order for
that part you will hear.
No, here one of the Justice Bhattacharya had said.
Let us see.
Yes.
That was in Port Blair. It's not binding. Different weather.
Single leg it is only for minors.
No, not. Where is it? It was held to be omitted, you said.
Yes, to that extent, minor can turn to paragraph 42. Paragraph 42, no? 43 is the omitted of the portion itself.
42.
Yes, my lord. Internal page 1705.
Yes.
From the observation made in paragraph 47 and 103 of the said reports, the court finds the issue that allows for consideration in the said paragraph was what would be the remedy when the appellate court either affirm or reverse the order rejecting the claim, thereby restoring the suit to be tried on merits. While answering such issue an opinion or express that such an order is in effect of order of remand or order pattern to of the court. Though Mr. Chatterjee placed on reliance on the observation made in the said paragraph in support of his pleading objection as to majority of this application, but first the observation was confined to the proceedings which allows under an order passed on order 7 rule 11 of the court as to whether an application for Article 227 of the Constitution of India is maintainable against the order of remand passed by the appellate court after reversing a degree disposing a suit on pleading point when trial court did not arise for consideration for the order of full bench in the said decision. This court is therefore considered view that the decision of order of full bench cannot be assisted by deciding the issue that allows for consideration in case in hand. For this reason, the reference of making in opposition the issue when the opposition in paragraph 100.
Was the case before justice?
Yes. Now, the case is my lord. You will also in paragraph 1, my lord. The application to the Constitution of India at the instance of the defendant number 2 to 5, directed against the order dated 1st July 2025, passed by the learned district judge, Andaman and Nicobar Island, title having number such as reversing the order being number such and such, passed by the learned joint civil judge, 2016. So it is similar to
This your case.
Yes, my case, and it was ultimately held, my lord, that revision is not maintainable. Because it is of the opinion.
What is the reason regarding that judgment? It was held to be omitted. But what is the independent
Yes.
reasoning of the learned single judge?
You are not find that is that. Paragraph 30 is subject to question, my lord.
30.
Justice Sales. Now, my lord, another thing cropped up for consideration. So people judge it by. If you guys consider, my lord.
We will consider.
Yes, that is you guys consider. Now, my lord, can you consider that what?
No, but remand remand arises when a judgment, an issue is decided and a review is checked. 7-11 is a
What 23, my lord, can you consider?
Yes, do. Let us see. CPC company.
Sir,
এদিকে ঘুরে এসে দাও ওটা কি এখানে কি করে আছে ফের আবার পোস্ট করতে পারছি আমি আগে ওইখানে ক্ষেত্রে ঠিক আছে order 43 years order 41 will take
আছে
it needed to be a remand.
Yes. Where in court from whose degree an appeal is favored as disposal of the suit upon a turning point and the degree is reversed in the appeal. The appeal court may its speed by order of demand. The case may further directed the issue. Directed what issue or issues shall be tried in case so remanded and shall send a copy of the judgment or order.
All right. So this is an order, it's an order by the appellate court. Therefore,
now, when people logically consider that way, the previous judgment was by this honorable court, where it says it is a rejection of order 7 rule 11 application. It is amounts to whether the appellate court had excessive power of the appeal, it is a reversal subject to question. But the seriously says
In your case, it has not been remanded as such.
Yeah, it is a remand because,
Appeal is allowed, there shall be no arrest.
Because-
Order and decree is set aside.
yes.
41-23 speaks about disposal of a suit on appeal.
Well, on the,
Order 14 we can understand.
that is an issue, but that is why one of the issues which have been tried in the order 40 rule 2.
Just because order 7 rule 11 rejection of a plaint is a deemed decree does not mean that in
Then
who has been decided.
what is the rule 10? Return of plate, my lord. It is also termed to be return of plate will termed to be a degree in that sense.
No, because 711 is a degree, rejection of plaint is a degree.
Deemed degree.
It's included in section 2.
Deemed degree.
It's a decree,
Yes.
but there is no issue adjudication.
So order 40 rule 23 is a logically concerned, it relates to issue.
Order 41 rule 23 says where the court from whose decree is preferred dispose of upon a preliminary point and the decree reversed in appeal, the appellate court may, if it thinks fit, by order remanded and may further direct what issue or issues shall be tried in the case to remand.
So issue come, my lord, when there is a
The issue is not in the first portion it's stated on a preliminary point.
Right.
But here no preliminary point was involved. Also. Point obviously in the sense is an issue. But if it's a preliminary issue, here it's not a remand case. If that be so, then Mr. Rai, then it's I mean it's an order passed by the first appellate court. There is a scope of remand. There is a scope of remand.
but
The suit was a non-starter.
remand when there is a,
Suppose at a mature stage of a suit, an order 7 rule 11 5
at any state.
at any stage rejected, similar situation arises. Then when that order is set aside, there is no scope of any remand because the suit is at an advanced stage and it has to proceed from there. So,
Yeah,
question of
same
remand.
case.
So therefore division should lie.
Then what that be so, my lord, then in view of this special bench,
Special bench, the point of reference was very limited.
and it has well the
Rest is omitted.
so if you are logically confident in that way, then also well, it has held in that sense, paragraph 30, that person was considered held to be unavailable. That is what my lord we have.
30 of justice. What is it?
What is the judgment? The other portions say held to be omitted regarding, but the appeal is better, that is subject to question, well, that was the ultimate.
We'll have to differ from that.
Yes.
We'll have to consider this and differ from that.
And the last and the least.
Why this? But not the least.
No, today is for this is the least.
By us. One of us.
That's been market. Where the last portion of the order.
Supreme Court.
Yes. Paragraph 15.
Not Justice Babs. Say Supreme Court's order. What is
Paragraph 15 and 16. Revise the division court jurisdiction need to pass an order rejecting the plate.
No, that was a rejection was sought under 226 and 227.
The one 227. Similar to get consideration.
Where a tenant paid for rejection of an alleged collusive suit between the heirs under Article 226 to 27.
Yeah,
There,
Under the-
like quashing of a proceeding.
yes. In the
That
line
was
of
defeated.
justification, the citizen may issue judgment, pass the High Court and allow the appeal to make it before that, if you are not considered.
See para 15?
Yes. Similar issue, favor reaction. Before that one, can you
When
consider
yes.
paragraph 13 and 14?
Yes.
These observation in first are not relevant for the matter. In
High Court had under 226 or 227 rejected a plaint here.
Yes.
That is para 2 of this judgment.
Yeah.
And the High Court in exercise of its supervisory jurisdiction can have 227 reject a plaint.
Yes. There it said one. So therefore, the revision against the rejection of claim under the revision.
That was not a revision. 227 power was exercised to reject the plaint.
Yes.
That was the first order. That was not a different thing.
But ultimately, it is that the procedure of provide this is legal infrastructure only.
Exactly, because order 7 rule 11 is available.
Short circuiting the procedure.
Precisely, short circuiting, because for the first time before the 227 court, it was thought that the claim be rejected. That was done. For that, the court, Supreme Court, quite rightly, in a humble view, felt that you cannot straight away come up in 227. This is not a criminal case. You seek a quashing of that case. This is a civil suit full pleasure. 227 jurisdiction was sought to be invoked to reject the claim. That was deprecated. Short circuiting, because order 7 rule 11 is applicable. You go there. This is different. No, the limited knowledge will
No.
and say that, and not even 226 to 27, Mr. Rai. 150, this is a typical 115 scenario. Because if the order was passed in your favor, it would have finally decided the suit. Plain rejection, not return. This is one of the few circumstances where 115 is maintained. 115 is maintained. We are holding that. Yes, Mr. Vittu, we are holding that you have to say anything, can I? If you say appeal is maintainable, you have to also. Because this is a legal question.
No, matter so far as this is concerned, I have no objection.
No, only this. Only because we will hold that we are holding it.
It was drawn up. Yeah.
Decree was drawn up. Erroneous. Decree was also drawn up.
Yes.
We will say that it is misconceived. Right now, take your seat, sir.
This is the list of final hearing this suit has been paid. Argument is just give you a 15th. If you lordship, that is why I have mentioned. Some protection will prefer the revision application there.
You have filed a second appeal.
Second appeal. That is within the period of application. So therefore, that protection I feel at least 7 days time so you can approach the revision court. With 7 days time, but this stays for period of 7 days, we can in the meeting will after that.
That would be more difficult.
More difficult.
We will have to file a revision appropriate format also. This is in a form of a memo.
Memo. The stay application with the ground, or memo is with the grounds, and the stay application will be the some gap, some.
Mr. Mithu, what do you say to that? 7 days time to file that revision. Only for 7 days.
7 days time.
At the outset, comma, a question of maintainability arises with regard to the present second appeal. Next para, the brief backdrop is that in a suit filed by the respondents herein, comma, an application filed by the present appellant within bracket defendant in the suit bracket closed under order 7 rule 11 of the Code of Civil Procedure was allowed, comma, thereby rejecting the claim. Next para, against such deemed decree, comma, a regular first appeal was preferred by the respondents, which, comma, by the impugned judgment, comma, was allowed on contest by the first appellate court, comma, giving rise to the present second appeal. Next para, learned counsel appearing for the appellant, comma, in support of the maintainability of the present second appeal, comma, cites a 3-judge bench decision of this court in the matter of Deputy Director Namgulo Didi, reported at 2023 SCC Online Cal 2914, where the Honorable Larger Bench, comma, inter alia observed, comma, while finding that the issue arose as to when the first appellate court either affirms the order rejecting the plaint or reverses the order, thereby restoring the suit to be tried on merits, comma, what would be the remedy available to an aggrieved party, comma, held that it is in effect an order of remand under Order 41 Rule 23. Next para, the larger bench further held that it is the nature of the jurisdiction that was emphasized and given predominance in the judgment discussed therein and ultimately found that the proper remedy in the said case would be to file a writ petition under Article 27 of the Constitution of India. Full stop. Next para. Although separate judgments were delivered by the honorable judges constituting the said bench, the conclusion of the conclusion was the same, to the above effect. Full stop. Next para. Learned counsel further cites a judgment of a learned single judge of this court in the matter of নামটা দিয়ে দেবে কস্টাইটেল bracket CO 75 of 2025, where it was held that against an order whereby the first appellate court reversed the rejection of a plaint by the trial court, the exercise would be under order 41 rule 23 of the court, and as such, an appeal would lie against such order under section 104, read with order 43 rule 1 within bracket small u of the code of civil procedure. While holding so, the learned single judge observed that the larger bench judgment referred to above, insofar as the contrary was held therein, was obiter dictum. Next para. Lastly, learned counsel for the appellant cites such and such reported at 2025 SCC Online SC 985, where the Honorable Supreme Court deprecated the invocation of constitutional powers for rejecting a plaint. Next para. Heard learned counsel for the parties. Next para. With utmost respect to the erudition of the members of the larger bench, in our opinion, the observation of the said bench to the effect that an application under Article 227 of the Constitution of India will lie in the event the appellate court rejects an order 7 rule 11 application was obiter dictum in the context of the said case. Full stop. Next para. The factual matrix of the said case was diametrically opposite to the present one. Full stop. The question which was referred to the said bench, in answer to which the judgment was passed by the larger bench, was as follows. Colon দিয়ে এটা 2023 SCC অনলাইনে যেটা প্রথম প্যারাগ্রাফে আইটালিক্সে আছে আমি লাগিয়ে দিচ্ছি ওইটাই হবে। Next paragraph. Thus, in the said case, the trial court had rejected the application for rejection of plaint under order 7 rule 11 of the Code of Civil Procedure, which was reversed by the first appellate court. Thus, the order of the first appellate court rejecting the plaint was in the nature of a deemed decree. Next para. Hence, the said judgment does not come to the aid of the appellant in the present case, not being a precedent on the issue which has arisen before us. Next para. Insofar as the judgment of the learned single judge in Lieutenant Governor of Andaman and Nicobar Islands Supra is concerned, with utmost respect, the observation we are unable to agree with the portion of the observation in the said judgment to the effect that where the first appellate court reverses the rejection of plaint, the said order should be treated to be an order of remand, and a further appeal lies against the same under order 23 rule 1 within bracket small u of the Code of Civil Procedure. Next para. perusal of the language of Order 41, Rule 23 would be beneficial in the context. Full stop. Next para. The said provision is set out here in below. Order 41 Rule 23 টা একটু করে দিই। আমি এখানে ইয়ে করে দিচ্ছি। একটা ট্যাগ লাগিয়ে দিচ্ছি। So next para. From a comprehensive reading of the said provision, comma, it is amply clear that by the expression double inverted preliminary point double inverted clause used therein, comma, the legislature intended to cover cases where a preliminary issue is decided within bracket, for example, under Order 14 of the Code of Civil Procedure, bracket close, full stop. Such construction would be in consonance with the rest of the provision, comma, since in such a case, comma, the appellate court has been empowered under Rule 23, comma, if it thinks fit, comma, to remand the case and further direct তারপর double inverted মধ্যে what issue or issues shall be tried double inverted clause in the case so remanded. Full stop. Next para. Furthermore, comma, in Order 23, comma, the language used is that when an appeal is preferred, that where the court from whose decree an appeal is preferred, তারপর double inverted মধ্যে has disposed of the suit upon a preliminary point, double inverted clause, full stop. The expression double inverted disposed of the suit, comma, obviously means that an issue has been decided in the preliminary form. Full stop. Next para. The rejection of a plaint under Order 7 Rule 11 of the Code is a deemed decree merely because it is stated to be so in Section 2 of the Code of Civil Procedure, which defines a decree. Full stop. However, comma, per se, comma, the rejection of a plaint does not involve the disposal of a suit or the decision on any issue whatsoever. Full stop. For qualifying as an double inverted of the issue, comma, an averment has to be made in the plaint, comma, which has to be controverted in the written statement, comma, thereby prompting the trial court to formulate a specific issue. Full stop. Unless such an issue is decided while disposing of the suit, comma, the rigors of Rule 23 of Order 41 cannot apply. Full stop. Even otherwise, comma, the rejection of a plaint cannot be equated with disposal of a suit, hyphen, either on a preliminary issue or otherwise. Full stop. Next para. Hence, comma, in the event the first appellate court sets aside a deemed decree rejecting the plaint, comma, the effect is that the application under Order 711 of the Code stands rejected, comma, which tantamounts at best to an order and not a decree or an appealable order or a remand order. Full stop. Next para. In such view of the matter, comma, in the event the first appellate court reverses a deemed decree rejecting a plaint, comma, such judgment of the first appellate court is to be treated as an order within the contemplation of the Code of Civil Procedure and an order under the Code of Civil Procedure simpliciter and not a remand order in the true sense of the term. To sub next para. In view of the order, in view of such order, comma, if passed in favor of the challenger, comma, having finally decided the suit by rejection of the plaint, comma, the trappings of Section 115 within bracket as amended bracket close of the Code of Civil Procedure are squarely applicable, and as such, comma, a revisional application under Section 115 of the Code of Civil Procedure is the remedy available to the aggrieved party against the order of the First Appellate Court rejecting the application under Order 7 to 11 of the Code of Civil Procedure. Full stop. Next para. In view of such observation, in view of the above comma, we hold the issue of we hold the maintainability issue against the appellant in the present case. Full stop. It is hereby observed that no second appeal, comma, is preferred in the instant case, comma, is maintainable against the impugned order, judgment, and order of the First Appellate Court, whereby the rejection of claim by the trial court was reversed, comma, thereby in effect rejecting the application under Order 7, Rule 11 of the Code of Civil Procedure. So, next para, we make it clear that despite a decree having been drawn up by the First Appellate Court in the present case, comma, the said decree was a
Suit.
Basically, suit.
In a suit, it does.
Suit matter. It checked last year.
DDR have both suit and appeal.
We are speaking of the appeal. Appellate court. We are saying that only. So where is saying no? We make it clear that despite a decree having been drawn up by the First Appellate Court in the instant case, comma, such decree was a misnomer, and drawing up of a decree was totally misconceived, comma, in view of the judgment not being a decree from any perspective whatsoever. Full stop. Next para. The mere ministerial act of drawing up of a decree cannot govern the parent provisions of the statute and so called determine the appellability or otherwise of the judgment in respect of which such decree has been drawn up. Full stop. Thus, comma, the drawing up of a decree by the First Appellate Court is totally irrelevant in the context of the present case, insofar as the issue of maintainability is concerned. Full stop. Next para. Accordingly, SAT 280 of 2025 is dismissed as not maintainable in view of the availability of an equally efficacious alternative remedy by way of a revisional application under Section 115 of the Code of Civil Procedure. Full stop. Consequentially, Can 1 of 2025 is also disposed of. Full stop. There will be no arrest to cost. Leave is granted to the learned advocate and record for the appellant to take back the certified copies of the judgments of both the courts below upon furnishing photocopies thereof. Full stop. Next para. Since we are informed that the next date of final hearing fixed in the trial court in the parent suit is tomorrow, that is January 15, 2026, comma, for the ends of justice, comma, we grant stay of all further proceedings of the suit till January 22, 2026, in order to enable the appellant to prefer divisional application before the appropriate bench of this court. Before the appropriate bench. Very well. The excess court fees, the court fees paid in connection with the second appeal shall be refunded to the appellant. Refunded to the appellant.
You will have to say something, my lord, because you not the judgment you have considered by the learned single bench of court there, my lord.
Yes.
Not there the court, my lord, entirely different. There the preliminary issue framed, the trial court passed after considering the preliminary. That order was challenged by in the first appeal court.
So there was a preliminary issue actually framed.
Yes.
We may incorporate that in our
and my lord, Justice Bhattacharya, my lord, while considering the order passed by the trial court and the direction by the learned district judge, my lord, remanding the matter, my lord, certain directions were passed upon the trial court, my lord. That is why, my lord, our case fall into the provision of order 43 rule 1.
Thank you very much. Thank you so much. We'll introduce one sentence probably in our today's order.
Yeah, one of the issues there. Please order the
In your case.
in my
No, in that case,
Yes.
while discussing that judgment,
Yes,
we'll
issue.
put that also.
Yes, issues there.
That was what we were wondering, because Justice Bhattacharya would not have done it.
Your lordship, since Miller has.
No, definitely, we'll have to put that in there. We'll put that in our order.
But I think the conclusion is the engineering portion is the kind of.
So then we need not differ from that judge.
And Miller, not only that, Miller, there
Minus
must
30 is the reason for
Full
this.
consider.
Miller, not only that, Miller, in our matter, Miller, trial court, Miller, had rejected their.
No, but Justice Bhattacharya held that there is the rejection of claim straight away. It was,
Yes, that
the
is why
observation was blanket.
Miller, if your lordship, Miller, consider.
In the light of that.
Yes, whole judgment, my lord, that was not the observation of
If that is made, we can add one line that in any event, in that case, issue was.
Yes.
Thank you very much.
Otherwise, my lord, it will.
Go wrong.
Yes, my lord, we will.
Next.
So we are also happy. But the division is also.
Next.
The department, the staff. The staff. Taken by the department concern.
যেখানে বললাম আগের অর্ডারটা বললাম চলে গেল একটা শুধু দিনের সংখ্যা নেই the court fees deposit shall be refunded by the department to the department to the yes yes is item 20 রাখেন 20 রাখেন কোনটা ম্যাটার
Not against my lord. Final disposal of the order petition rule 1 third application, where my lord. An interim injunction, my lord, that was granted earlier, my lord.
partition suit
But kindly, my lord, takes up my lord, my application once, and my lord, the averment of the plaintiff, my lord, with respect to my status.
depends to the getting nature and character
But kindly sees, my lord, what the plaintiff says. Whether my lord, the suit at all, or my lord, the application at all is maintainable or not. May I put this question?
which page
My lord, my application, my lord, the plain starts at my lord, page 6.
which averments be depend to Mr. Banerjee
My lord, paragraph number 3, my lord, kindly comes.
yes
My lord, please. Jonathan Hasda, Narayan Ranjan, Noyan Ranjan Hasda, and Shuniti Shodan with the honors in plot number such and such. The father of the defendant number 1 and 2 named Shakti Padadas used to possess the plot number 176 area 10 forcibly by making house which is specifically mentioned in the A1 schedule land mentioned in the plan which is shown in red color border to the annexed map. The annexed map is part of the plan. A1 schedule land is the part of the A schedule land. And one of the remaining of the paragraphs goes on to say that I am forcibly possessing the land. And one of kindly consider the partitions has already been filed against me. Whether my lord, even if I was the pro forma respondent, my lord, dependent, my lord, whether the partitions was maintainable. But my lord, kindly my lord, takes up the first title, my lord, page number 6.
no you are a pro forma respondent
No, I'm the defendant. Only two defendants. My father, they say my father used to forcibly possess that land.
yes.
After my father's death, they have made my lord, the partition suit against me. They have filed the partition suit against me. And my lord,
your father must have been admitted to be a co-owner
no, my lord, that is why my lord, I have my lord, paragraph number 3. My lord. Only averment is that forcibly their father was possessing the said. Shakti Padadas was possessing.
what are you saying somewhere they must have been
Kindly, my lord, take my lord, paragraph number 4, my lord, kindly takes up. That Ganadon Hajra, Noyan Ranjan Hasna, and Shuniti Shodan used to possess jointly rest 40 decimal of the land in plot 176. After demise of Jonathan Hasna, his 1/3 share inherited by his two sons, Oshim and Amit, who are the plaintiffs. And the plaintiff number 1 and 2. And after demise of Noyan, his daughter Avantika Hasna Murmu, the plaintiff number 3, inherited 1/3 share of late Noyan Ranjan Hasna. After demise of Shuniti Shodan, her son Shamal Shodan inherited 1/3 share. After demise of Shakti Padadas, his two sons, namely Deepak and Shopon Das, the defendant number 1 and 2, inherited jointly the land left by Shakti Brothers. After, in the previous paragraph, they say that my father forcibly possessed the land. Next paragraph, they say that I have inherited jointly. Now, my lord, my whole written statement case is, my lord, that
No, after demise of Shaktiboda, you inherited jointly
inherited jointly.
the land left by Shaktiboda. It's contradictory reading.
So, my lord, and my kind my lord takes up my lord my written statement.
But they admit in the very next sentence that the defendant numbers 1 and 2 have jointly. Probably they mean to say that your father, despite being a corner and every corner having right over every inch, he forcibly took over a particular portion and made a construction. That is the intention. You have to read it harmoniously.
Kindly, my lord, takes up.
They say in the same breath that you jointly have a share through Shaktiboda. Therefore, Shaktiboda has been admitted to be.
My written statement is, my written statement case is
Yes.
that it's a case of adverse possession. My father initially did not have a title, but has been my lord residing in the property for the longest for a long period of time adversely, and as such, at the moment, my lord, he cannot be disposed. Takes up my lord, page 21.
Parties should they have admitted your title and you are saying you're in adverse possession.
Well, this is one kindly concerns, my lord, this is not admission, my lord, so far as my lord, paragraph number 3 is
You
concerned.
say adverse possession, it's an admission of the title of this.
They are, my lord, they are pleadings. They are claimed, my lord. They are claimed, my lord, paragraph number 3 is not, my lord, admission, so far as my lord concerned.
No, you are admitting. If you say you are in adverse possession, you are admitting the title of the plaintiff. There cannot be any adverse possession. You are admitted to be a co-owner, and it has been stated that defendant numbers 1 and 2 jointly have share in the property. And you file a written statement by saying that you have adverse possession. Both of you are equally benefited by legal advice. Paragraph?
Paragraph 11.
Yes, 11.
Page 21.
Yes, you have stated adverse possession.
Adverse possession. Adversely possessed by the predecessor of the defendants with the knowledge of the predecessor of the plaintiff since 1352 openly adversely and is entirely within the knowledge of the right of the predecessor of the plaintiff continuously without.
What is your answer to para 4? Para 1 to, oh, this is answer to para 1 to 6. No. That is.
I've dealt with para 4, but
let us see how you have not admitted the.
Paragraph number 7.
Not admitted that Ganranjan, etc. Or that after divorce is share related petitions. Or that after divorce. You have denied that also, that after divorce of your father. Great. You have denied your title and you say you are in adverse possession. You want to prove your adverse possession.
Well, in a partition suit, that is the only question. Whether the partition suit, they have not clearly stated that I have title. They have said that my father was forcibly possessing the
They
right.
say you have joint possession. No, they say forcible possession is regarding a portion. They say their exact language is that your father, namely such and such, used to possess plot number 176, which is a part of the suit property. Forcibly by making house, which is specifically mentioned in A1. And in a particular portion of that co-ownership of the joint property, your father forcibly occupied and made a construction.
Kindly, A by 1 is a part of the entire suit property.
Yes, you have forcibly occupied that and taken it exclusively and made a house. That is their allegation. In the next paragraph, they say that your father was the co-owner all the same, and you inherit through them. That is admitted. It's a partition suit after all. You are the only defendant. Unless your title is admitted, how can a partition? And you go up and say, file a statement saying that you deny that and you have adverse possession. Why would the appeal be entertained unless you show evidence of adverse possession? Why should you entertain your appeal? You should also look into equity. So the trial court was obviously confused enough to grant the status, and we are also confused, equally confused.
So kindly will cease matter the observation of the learned
Only a supervening impossibility can save your defense. The pure force majeure case, in as much as your defense is concerned.
But that part be clarified, madam.
What part we clarify?
Kindly,
They admit, they say you have shares in the property, your father had shares, through him you have shares in the property, and you go up in your written statement and you deny that you have shares, and you say you are in adverse position.
Adverse position.
Without reading the details also.
Adverse position so far as the entire property is concerned. The plotting.
How can a co-owner be in adverse position regarding the entire property? Or plotting?
My humble submission to the probably
Ouster could have been pleaded. Court is absolutely correct in fact. Just see. In the present suit, there is no such plea of ouster by the defendant against the plaintiff. Exactly. The decree should be passed on admission. You have admitted you don't have any title. Adverse question ingredients you have not pleaded. Date, how you entered.
Kindly, my lord.
You'll pass the judgment of admission from here.
So far, my lord, that part is concerned, my lord. They have also, my lord, they have claimed, my lord, suffers from, my lord, just defect, my lord, that they have not pleaded, my lord, how, my lord.
Your suffering is worse. No, we won't do that. The present challenge has been preferred against an order whereby a temporary injunction application filed by the plaintiff stroke respondents was allowed, thereby directing both parties to maintain status quo in respect of nature and character and possession of the nature, character and possession of the suit property till disposal of the suit. So the next parallel counsel for the appellants argues that the partition suit itself is not maintainable in view of the plaintiffs having pleaded in paragraph number 3 of the plaint that the father of the present defendants, namely Shaktipada Das, used to forcibly possess a portion of the suit property demarcated as Schedule A/1 and built a house thereon. For sub next para, learned counsel places reliance on the relevant paragraph, that is paragraph 11 of the written statement, to show that the defendants stroke appellants on the other hand have claimed adverse possession. For sub next para, learned counsel for the appellants argues that since the suit, as framed, for the relief of partition is not maintainable in view of the admission of the plaintiffs that the defendant stroke appellant's father did not have any title in the property, the learned trial judge erred in law in granting injunction. It is contended that the maintainability of the suit is a component of the prima facie case. Next para, it is further submitted that on the facts pleaded, the injunction order could not have been passed, particularly since it has been admitted that already a house has been constructed on a portion of the property. Next para, on a careful perusal of the plaint, we however find that the contentions of the appellants cannot be entirely accepted. It is a trite principle that the pleadings of parties have to be harmoniously construed as a whole, and isolated excerpts, excerpts from the same cannot be taken out of context in order to examine the nature of the pleadings. Next para, following such principle, paragraph number 3, read with paragraph number 4 of the plaint clearly indicates the plaint case that the other of the defendants stroke appellants, namely Shaktipada Das, was a co-sharer of the suit property, upon whose demise the present defendant stroke appellants have inherited jointly the property held by Shaktipada Das. Full stop. Next para, insofar as the averment in paragraph 3 regarding Shaktipada having forcibly possessed a portion of the plot is concerned, comma, the same is in the nature of a pleading of ouster and does not per se deny the title of Shaktipada in the suit property. Full stop. Next para, moreover, comma, since the very premise of the partition suit is that the defendants are co-owners, comma, and their specific shares have also been delineated in paragraph number 4 of the plaint, comma, it cannot be said at this juncture that the partition suit is not maintainable. Full stop. Next para, in such view of the matter, comma, we are of the opinion that the learned trial judge was justified in passing an order of status quo, comma, since it is a well-settled proposition of law that during pendency of a partition suit, comma, in aid of the final relief sought, comma, the subject property ought to be maintained in statu quo. Status statu quo. Which of next para, accordingly, we do not find any illegality in the impugned order. Full stop. Hence, comma, FMA 1716 of 2025 is dismissed under order factor rule 11 of the Code of Civil Procedure. Consequentially, can 1 of 2025 stands dismissed as well. No order is to cost. Full stop. Next para, it is made clear that the learned trial judge shall dispose of the suit from which the present appeal arises independently and in accordance with law without being influenced in any manner on the observations made herein insofar as the merits of the respective contentions of the parties are concerned. Mr. Banerjee, please advise your client properly. You're in for trouble otherwise, your client. And give proper advice to your client what to do in the trial regarding the mistake.
WS was 5 mallet.
See, it can be damaged somehow. Cannot withdraw an admission, but we won't advise you for it because the other side is not present. Yes.
Item number 21.
Yes. Identity or final? You are enjoying identity?
No, my lord, I was not enjoying. But the facts of the case are, my lord, during the pendency of the suit, I purchased property from one of the defendants. Now, my lord, on 5th July 2024, my lord, the suit was filed and an identity order of injunction was filed. The plaintiff sought for an injunction order from the trial court, my lord. The plaintiff's nature of seeking the injunction
You are the
order was-
plaintiff.
No, my lord, I am the added defendant.
Acha. The plaintiff, acha, correct. So the plaintiff case was that he purchased a portion of the property from
One of the defendants.
his share, that defendant's share.
That defendant share I have purchased, my lord. After purchase, I didn't knew at that point of time that there was a partition suit pending. But on 5th July, the partition suit was
No,
filed.
plaintiff case is that the plaintiff purchased that share.
No, my lord. The plaintiff case is that the plaintiff and the defendant both have shares in that property.
Acha, you have purchased the property. You
My
say
lord, I have purchased the property on the defendant.
his share or entire?
On the defendant. Only the defendant share. My lord, who is the pro forma defendant in this appeal?
You purchased before the suit.
My lord, I have purchased during the pendency of the suit.
Acha, then
My lord, 5th July, the suit was filed. I have purchased on 8th July. Now, my lord, on the date, my lord, when the suit was filed, my lord, two orders were sought by the plaintiff from the learned trial court, my lord. One is that his position may not be disturbed, and another is, my lord, an injunction of the third party interest. Now, my lord, the injunction of the third party interest was not given by the learned trial court, my lord. So that one disturbs his position over the suit property, my lord, that injunction was not. Now, my lord, I purchased, unknowingly, my lord, I purchased on 8/7/2020. Thereafter, my lord,
so then the possession injunction was there.
the
But
position injunction was not there, third party interest.
so your sale is not vitiated.
No, my sale is not vitiated. I will show that, my lord, the order has been ended. My sale is not vitiated.
Right.
Now, my lord, I purchased the property, my lord. I filed an application under order 110 with the learned trial. That gets allowed on consent.
Acha.
That gets allowed on consent, my lord. And my lord, on that day, I filed an application under order 39/7 for inspection of, since my lord, my allegation was that they are encroaching upon my property and they are making construction.
Your case is that your vendor handed over possession to you.
Mine.
Regarding that portion.
Mine.
Well, till now it is not right for me to file a register well, because I have filed an application under order 1 and then the injunction application hearing was going on. Well, now I filed an application under order 1 that was allowed, order 13 was allowed, and I also filed an order 13 1 and 2 saying that there should be a status quo over the entire process. Since I am also a co-owner in the party.
And his injunction was restraint order from disturbing his person
Peaceful position.
and also change of transfer.
The third party.
Achha, you asked for status blanket
Should be property.
all right.
Now, my lord, the learned trial dismissed, rejected both the injunction applications. I don't know, I also include order.
What was the premise of dismissal? Let us see.
Well, the learned trial judge says since the property is accessible by all means and the property is on road, so my lord, no injunction order is needed.
You don't understand.
My lord, kindly comes to page number 2 of the order, my lord.
Yes. No, first, their petition was allegation was blown out, but there is principle known as lease pending. Lease pending.
I was the third party interest when was transferred by the defendant number 1 in favor of added defendant has already been created, and by way of lease pendant right now, added defendant kept key possession of the defendant.
They should also challenge. Because of lease pending in a partisanship no injunction will be granted.
My deed has also not been challenged later. Even my order 1 has been allowed by consent.
Exactly.
So my lord, I have a better
Let us forget about that. They have not challenged. So let us
I have a better case.
Yes, let us see. Now come to the temporaries. So here values that the plaintiff has made encroach the best portion of the property and being constructed.
My portion of the property is my deed. There is a demarcation. There is a demarcation.
But that cannot be. That cannot be. Because the questioner cannot face that.
But my
Effect will be that his share is.
His share, my lord.
And all of you have right over agreements.
My case is that they have encroached my
Best portion. My portion is not. We cannot. But best portion we can understand. Let us see there. Please read the second paragraph onwards.
From the said Panchayat plan, it appears that the entire school property is covered with main Kandi Gaurampur road. So both the parties can enjoy the access of the road equally. Well, this was a premise. It is the fact that this is a partition suit and admittedly both parties have share in the suit property. It is settled principle of law that every co-sharer has right over every molecule of the co-sharer.
He has gone to the molecular level, which is good.
Well, this was
till now it was inch.
Well, this premise should have been the premise of granting me injunction.
No, because molecule was mentioned here, the quantum theory was resorted to. Right? This order is a Schrödinger's cat. So it is alive as well as dead.
Property molecule of co-sharer property. At the same time, we have to keep in mind that plaintiff has substantial share as well as he obtained required conversion and sanctioned building plan for alleged construction, which is now being stopped. Apart from all these things, a report of local inspection dated such and such has also been submitted.
No, but there is a point. There is a point in the sense that he has obtained a sanction claim. He started construction. You purchased after that, and then you come and.
My case is not. My case is not. He may have obtained sanction plan. I do not know that.
But yes, but you after that you purchase the property, although without knowing, but you purchase the property after that. You are an outsider to the property when he obtained the sanction plan. He being a co-sharer obtained a sanction plan, started construction.
They have not started much construction. They are about to start because in fact, my lord.
But they have obtained a sanction plan. They are about to start construction. Now you come up and say.
My lord, because but my lord,
let us see the injunction prayer. Your injunction prayer. Was the prayer
comes to page number 50. My lord, it's not. My lord, 43. 44 is a prayer. এই মতে প্রার্থনা উপরোক্ত অবস্থাতে বিবেচনা করিয়া উক্ত মোকদ্দমার চূড়ান্ত নিষ্পত্তি না হওয়া তো যাতে বাদী নালিশি সম্পত্তির অ্যাডিং বিবাদী খালি করিতে দখলীয় স্থানাদি হইতে গায়ের জোরে বেদখল করিয়া নালিশি দাগে সম্পত্তি ফাঁকা রাস্তার ঘাট বরাবর সমগ্র বেস পোর্শন থাকা প্রাচীর দিয়া ঘিরিয়া লইতে না পারেন বা বেস পোর্শন ঘুরিয়া কোনো রকম কনস্ট্রাকশন করিতে না পারেন এবং নালিশি সম্পত্তি নেচার এন্ড ক্যারেক্টার চেঞ্জ করিতে না পারেন।
What about the commissioner's report? Report, yes.
My lord, the local inspection report, my lord, kindly comes to page number.
Mr. Banerjee, what was the revision about?
My lord, there was
Well, I guess
there was an
that is-
earlier appeal, my lord, because my lord,
No, revision 39.7. Oh, appeal. That's
well, there was an earlier appeal. My lord,
identity.
I claim against identity appeal, my lord, that was disposed of by directing the child court to take up.
Decide the final report. Let us see. Yes,
My lord, the remaining part is the page number 51.
51. Right.
My lord, also Ilakadhin
So construction materials were there.
Yes, my construction materials. were
Acha, to your injunction application, did the plaintiff file any written objection?
No, my lord, they have not filed any written objection. We have filed an exception to the local inspections report, my lord, saying that my lord, there are materials, so my lord, the court should grant the injunction. To that, they have filed a.
No, why did you file an exception to the report if in your favor?
No, my lord, the report is in my favor, but my lord, the court was of the opinion that since the materials were there, since there was no construction going on, so the status quo should not be granted. So we say, well, the materials are there, the construction may start at any point.
So why did you file an exception to this report? This report is in your favor. ও আচ্ছা আচ্ছা উক্ত সম্পত্তির উপর কোনরূপ কনস্ট্রাকশন কার্যাদি চলিতেছে দেখিলাম না
Mine. To that we have filed.
বাট হি হেড দ্যাট পূর্বাংশে ইট পাথর বালি মজুদ করে দিয়েছে
Mine.
যে যখন কমিশনের কাছে তখন মেটেরিয়াল আছে মেটেরিয়াল হয়েছে মানে কনস্ট্রাকশন করার জন্য ইট পাথর বালি কেন রেখে দেবো যখন গেছে তখন কোনো কমিশনের নেই বলছে এই সম্পত্তি পূর্বাংশে ইট পাথর বালি কিন্তু কোনো কনস্ট্রাকশন করতে দেখিনি সেটা নেই বলেই তো করছে করতে বলে sanction plan আছে সেটা have they annex the sanction plan
They have not given us copy. They have given to the court. I mean, we take this instruction from London trial.
no you are sure that no written objection was filed
No, my lord, they have only filed this objection page number 64. My lord, it is nomenclated as written objection of the plaintiff against the petition dated 24/10/2020. This is my exception. We have filed an exception to it.
no the sanction plan has never been mentioned
No, sanction plan has never been given to us, and they have never taken
no,
that.
no not given to you we said that it was mentioned by them anywhere
No, my
in the plain have they
lord.
mentioned
No, my lord. Fine, this is the plain, my lord, because it is a one-page plain.
one page plain
Yes, my lord. Kindly comes to.
thank you
On page number 13. Page number 13 is the plain, my lord. Page number 43 is the.
only one defendant
Well, from this defendant only, my lord, I got.
it was admitted that that defendant is
Have you shared in the property?
not only share দক্ষিণ দিকের না উত্তর দিকের অংশাদি ভোগ দখল করছে
My lord.
the construction according to is being made on the northern side
My lord, in my one report. My lord, in my my lord, page number 50 is the initial identity order. My lord, we kindly see there was no R and third party information.
The present appeal has been preferred against an order whereby the temporary injunction applications filed by the plaintiff is respondent number 1 here. Plaintiff respondent number 1, as well as the added defendant appellant were dismissed. Next para, learned counsel for the appellant submits that the suit was instituted by the plaintiff against the original defendant, in the plaint, it was admitted that the original defendant was in occupation of the northern side of the suit property, whereas the plaintiff on the southern side thereof, as per their understanding. Next para, immediately after institution of the suit, of the suit, which was then beyond the knowledge of the present appellant, the sole defendant transferred his share of the property by demarcation in favor of the present appellant. Next para, on the strength of such purchase, subsequently upon coming to know of the suit, the appellant took out an application for being added as a party to the suit under Order 1, Rule 10 of the Code of Civil Procedure, which was allowed on consent.
My lord, page number 42 kindly comes. One line, my lord. One minor, Anisul Rahman, returning to his minor, to his mother Kariba Bibi, filed a petition under Order 1, Rule 10 for adding as defendant. Petition is formally in nature and accordingly.
Not on consent, which was allowed with a order dated June 17, 2025. Next para, it is submitted that the said application for addition of party was observed by the learned trial judge to be formal in nature and was allowed without any contest by the plaintiff. Next para, subsequently, since the plaintiff attempted to make construction by disturbing the possession of the added defendant present appellant in respect of his purchased portion, a temporary injunction application was filed by the present appellant. Next para, in support of the same, a local inspection was also sought, which was allowed. The commissioner's report indicates that construction materials are stored on the property, although no construction was going on at the time when the commissioner visited the property. Next para, it is argued that in view of the appellant, in view of the plaintiff respondent number 1 seeking to raise construction, which is an admitted position, since the plaintiff apparently relied on some conversion certificate and panchayat plan, copies of which were never given to the appellant, there is immediate danger of the best portion of the property being altered by the plaintiff respondent number 1, thereby necessitating injunction to be imposed. However, the learned trial judge overlooked the said aspects and merely on the basis of such purported panchayat plan, permitted the plaintiff to make such construction without granting any injunction. So next para. On a perusal of the plaint, comma, we find that in paragraph number 3 thereof, the plaintiff stroke respondent number 1 has admitted that the original defendant is in occupation of the northern portion of the suit property, whereas the plaintiff stroke respondent number 1 is in possession of the southern side thereof. Full stop. Next para. It is further found from the commissioner's report that although at the juncture when the commissioner visited the spot, comma, no construction was going on, comma, nonetheless, comma, construction materials were accumulated on the property, comma, which apparently indicates the intention of the plaintiff to make construction. Whose next para, in fact, comma, in the impugned order, comma, it is recorded that the plaintiff submitted photocopies of conversion certificate as well as Panchayat plan. To sub next para, however, comma, prima facie, comma, the learned trial judge erred in law in relying on such photocopies, comma, since no written objection was filed by the plaintiff stroke respondent number 1 to the injunction application of the added defendant stroke appellant, comma, nor was any copy of the said documents handed over to the present appellant. Full stop. It is well settled that there cannot be proof beyond pleadings. Full stop. By following such principle, comma, the reliance of the learned trial judge on mere photocopies of purported conversion certificate and Panchayat plan, comma, without there being any pleading to that effect from the on the part of the plaintiff, comma, was erroneous. Full stop. Moreover, comma, the fact that the commissioner's report indicates that there is no new construction yet commenced on the property and that construction materials have been accumulated on a portion of the property, comma, it was all the more necessary for the learned trial judge, comma, in order to protect the suit property till the disposal of the suit, comma, to grant injunction, comma, for maintaining the property in statu quo. To sub next para, it is not the case of the plaintiff stroke respondent number 1 that any construction has already been commenced or is on the verge of being finished, semicolon. On the contrary, comma, the commissioner's report shows that there is an old structure but no new construction has yet been commenced. So thus, comma, the balance of convenience and inconvenience and prima facie case are in favor of grant of injunction in favor of the defendant, added defendant stroke appellant. Hence, comma, the appeal is hence, comma, the appeal bearing FMA 8 of 2026 is admitted, comma, to be heard on the above questions and the other grounds taken in the memorandum of appeal, in view of a prima facie case having been made out, comma, the plaintiff, your prayer is only against the plaintiff. The plaintiff stroke respondent number 1 and or his men and agents are restrained by an order of injunction from changing the nature, character, and or position in respect of the suit property till disposal of the present application. Push-up. Next para. The appellant shall serve a copy of the application, shall serve copies of the application as well as the memorandum of appeal on the respondent number 1, indicating that the application shall be listed for hearing in the monthly list of February 2026 and file an affidavit to that effect on the returnable date. Push-up. Service on the defendant's pro forma respondent is number 2 is dispensed with in view of no relief having been sought against the pro forma respondent. Yes.
Item number 22.
I am somewhere in the petition. Yes.
remains to be decided before the appearance. But my lord, before filing my lord, before submitting further my lord, maintain my lord, we have served my lord the private respondent. It has come back my lord deceased. Although my lord, at no stage my lord he appeared. For the first time, this has come back my lord with an endorsement deceased. And it must be my lord.
The difficulty that you're fair enough, but the difficulty is that unlike an appeal, the principles of order of return, those two provisions do not apply because this is an original writ petition. So you should take information about the heirs.
Yes, I can. 7 days government will keep it, my lord.
7 days will suffice.
But in the monthly of February.
Affidavit of service filed to be kept on record, full of learned counsel for the petitioners, in his usual fairness, hands over a copy of the envelopes sought to be sent on the private respondents, from which it appears that the only one private respondent,
Only one private.
private respondent, from which it appears, no, there are several. No, sorry, we are
Petitioners are
petitioners. On the private respondent, it appears that the private respondent
Private respondent, my lord, Sebaid back.
that the Shebite of the private respondent stroke idol, namely Jagadish Chandra Sahu, who has been arrayed as a Shebite to represent the idol, has died. To sub next para, since the juristic personality conferred on an idol is a legal fiction, and it is the Shebite through whom an idol functions, we are of the opinion that the current Shebites and or the heirs of the erstwhile Shebite Jagadish Chandra Sahu, since deceased, are required to be implemented for a proper adjudication of the present writ petition. Accordingly, the petitioner is the petitioners are granted leave to ascertain as to whether there are any surviving Shebites and or the particulars of the heirs of the deceased Shebite Jagadish Chandra Sahu, and make appropriate prayers before this court for addition of the said persons as respondents, private respondents in the present proceeding. Next para, for such purpose, on the prayer of learned counsel for the petitioner, the matter is adjourned and will be listed in the monthly list of February 2026. Please ascertain whether there is any surviving Shebite. If there is any Shebite, then it will be an order 22 rule 10 7. Was it the private property?
Findings of the government or the private government.
Private. We'll have to go by that, then his heirs can also come.
Item number 23.
Yes.
Actually, an order passed by the honorable tribunal. The orders were shot with background matter, but
You're for the respondent. Why a court? Why do you take the brief then? He is not? Yes, Mr. Shamara.
Suitable very short matter. Preliminary points also. This original application has not been annexed to the writ. I do not.
That's not a preliminary objection.
My prayer for occupational charges. I know, actually, and this order is against because rejection of an improperty application ENA 312. That ENA is also not there.
Annex the documents, Mr.
That
the document?
application is not annexed.
We'll grant her time on her prayer, but
That neither ENA nor ENA.
affidavit of service filed to be kept on record. Learned counsel for an adjournment is sought on behalf of the private respondent. Learned senior government advocate appearing for the state points out that relevant pleadings and documents have not been annexed to the application. Next para, learned counsel for the petitioners is requested to furnish the relevant copies of the connected pleadings and other judgment documents on the next date of hearing, comma, upon circulation of advance copies of the same to the learned advocates for the respondents. Full stop. How soon can you get hold of those documents?
By this week.
You have to give the advance.
No, but I
We'll keep it next Tuesday then.
next.
Very good. The matter shall next be listed under the same heading on January 20, 2026.
Great.
এগুলো নিয়ে নেবো।
Item number 24.
Yes. We think we should permit you to sit and argue because of the size of the microphone. Is appearing?
Mohammed Sarwar Zaman. This is code number 11.
So what you start the matter?
My instruction, my today.
What instruction? You have to be start the matter. You're carrying something. So it must be there.
For one.
No, start the matter. How long are you practicing dance? 2 years, start the matter. No, start the matter. We won't grant time. Then we'll dismiss for default. If you start, then we can think about granting time. No, otherwise no time. Sorry. You have to start the matter. If you ask for adjournment in this court, you have to start the matter. Sorry. What is the matter about? Yes.
If you know that passed by the mind, the West Bengal land becomes.
Mr. Bandhavati, take your seat. Let us start. Yes.
Today I am not ready, my lord.
No, even then you have to start. Whatever your readiness level of preparedness, start with that. What have you challenged here?
My lord, had November 25, order passed by
Land reforms and tenancy tribunal. Yes. What did it start with? I mean, what was the order passed? Where is the order? Which page?
Which page? I think on the last page, my lord.
Only on the ground of maintainability. What was the application for?
Correction of record of right, my lord.
No, the tribunal observed that it appears from page 53 annexure P6 that the order in this case such and such was passed by DL and LR. But after it appeared, whatever the language, but you asked for a certified copy that was not given. For that you have made it up. We'll give them that liberty. Where is that annexure, Mr. Bandhavati? Please help us.
P6 below, that is what you indicate on page 117.
Yes.
This case number such and such, why order dated that one, for the DLLRO? All got it?
Yes. Passed by the DL. Right.
And when the page 58 where it is 7 below, that is page 122.
Yes.
That is the application for manufacturer. Before the BLL. Order passed by the DLL comes up, we apply before the BLL.
Where is the prayer portion in there? Let us, yes, you'll find it out.
Prayer of the repetition.
No, not prayer of the prayer of the
Wait.
Wait. Yes. Where is that? Which page, man?
We are on page 75. We are on paragraph 3.15. 2.14 and 15.
No, the prayer portion.
Prayer portion below
82.
below 80. 80. Oh, it is 40. It is 40.
No wrong. The part of the tribunal.
Take your breath.
A confusion.
Why
that
isn't
was-
your junior ready, Mr. Jan?
But
You know the rule of this court.
it's a matter of my senior.
So what?
So I am ready for my senior.
No. Sub junior should be ready also. 2 years practice is
I
sufficient.
shall make it.
How soon did you open your mouth?
And
How soon did you open your mouth after joining profession? Not within 2 years.
within 7 days.
Then
Well, I shall take care of this. What the proceeding?
apparently DLLR passed the order and we applied before the BLLR.
No.
Then
The order passed by the BLRO. Terms of direction given by DLRO. I applied before the BLRO for certificate copy.
right,
But while made the legal representation,
that was wrong. That D was wrong.
that was the subject. That
Because
was
in the body of the application also it
everything
appears.
has been quoted.
Mr. Bandhavati, in the body of the application they have said that BLLR page 75, 6.15. We are looking through that.
Yes,
It appears that this case was that order was passed by the BLLR.
yes.
So that DLLR representation was wrong. And what other reliefs have you sought? You did not prefer a challenge before the DLLR, Mr.
I got
Oh,
a
you did not get
certificate copy.
So your primary relief in this OA is getting certified.
Certificate copy from the BLRO. He thought it's a order passed by the DLRO. I asked before the BLRO. That's a misconception.
But you also wrote to the BLLR at page 120.
Yes. My prayer is before the BLRO. I need a certified copy.
Mr. Bandhavati will dispose of the, I mean, we won't relegate it to the tribunal for this. We'll direct the BLLR to give a certified copy of that order.
That will survive.
Fair enough. The ambit of the present writ petition is limited. Full stop. An order was passed in miscellaneous case number 1 of 2013, according to the writ petitioners, by the Block Land and Land Reforms Officer, Lalgola, of which a certified copy was sought by the writ petitioners. Full stop. Next para. Although initially a representation in that regard was erroneously made before the concerned District Land and Land Reforms Officer, DL and LRO, closed, subsequently a representation was also made on July 30, 2025 to the BL and LRO seeking the order sheet of the said miscellaneous case, which, having not been furnished, the original application was preferred before the tribunal. So, next para, by the impugned order, the learned tribunal rejected the original application as not maintainable, apparently on the premise that the order was passed by the DL and LRO, whereas the certified copy was sought from the BL and LRO. So, next para, since we find from the averments in the original application itself that the order passed in the concerned miscase bearing miscellaneous case number 1 of 2013 was passed by the block BL and LRO Lalgola, this court is of the opinion that the petitioners were justified in applying for certified copy of the order sheet of the said case from the said BL and LRO. Full stop. However, upon hearing learned counsel for the parties, we find it unnecessary to relegate the parties again to the tribunal for such innocuous relief. Full stop. Hence, WPLRT 201 of 2025 is disposed of by directing the respondent number 4, that is the Block Land and Land Reforms Officer Lalgola, to furnish certified copies of the order sheet in respect of miscellaneous case number 01 of 2013 to the writ petitioners, subject to the writ petitioners depositing the necessary costs for the same, as expeditiously as possible, preferably within 4 weeks from the date of communication of this order to the respondent number 4. Full stop. The impugned order bearing order dated November 3, 2025, passed by the third bench, West Bengal Land Reforms and Tenancy Tribunal, is accordingly set aside. No orders to cost. Quickly application.
Item number 25.
They have applied for mutation to cooperative society and own their own name mutated the name. And we have challenged this order to the aggregate of it. Now the most incurable information what has been done by the tribunal, they have not challenged the order of the aggregate of the tribunal.
So what have you done? What is the challenge against?
They have challenged the inaction on the part of the respondent after going through the center orders, case 69, you also stand to see that there has been an order of the aggregate of the which ought to be challenged before the tribunal.
But we can give you that liberty subject to limitation.
Lots of it. And because tribunals are possibly, and because I have gone through this, then I will
Fair
share this. Because page 69, your losses can see the aggregate of it is not.
That ground, my lord, that is the application is there, so your application is that is the, and other grounds is also there.
Oh.
The application which he filed that application, that is not in.
Because
According to the
this order of the aggregate of it has not been handed over to the land advocate for the tribunal, that's why the tribunal was rejecting my application at
The order at page 70.
Yes, sir.
Appellant files Hajira.
Page 69.
This appellant was you, your client.
Yes. Page 69 is the order of the aggregate and the ground of limitation.
69 is the cover page.
Yes.
Order is at page 70.
Order dated 8 February 2020. And the ultimate, what it happens that you will stand to see the improved order at page internal 4 of the orders of the tribunal. Because this release people might not what it happens page 4 of the order, internal page 4 of this order. That will also stand to see second paragraph top. Next, the learned advocate has continued. Page internal page 4 of the order. Second paragraph.
Yes.
Next, the learned advocate has continued. No appeal has been prepared, but actually the appeal has been prepared. This has been not handed over to the learned advocate for the learned. That's why I will pass you, my lord. So I already submitted for lawsuit. I will find a fresh way challenging the order of the appeal.
So what was the order passed by the tribe?
They have inaction on the part of the muted.
Was it dealt with on merits also?
No, this is not being dealt.
Appeal secretary is not to consider the application.
This is not only the subject matter of the tribunal before the.
This order is an appealable order. Right? So they also submit.
Yes. Your lordship, really like to file the application for one.
Very. Learned counsel for the writ petitioner's submits. One writ petitioner also. Writ petitioner submits that despite an order being passed by the appellate authority in an appeal under section 54 of the West Bengal Land Reforms Act 1955, that is order dated February 8, 2024, passed in LRP number 309 of 2023, due to communication gap and inadvertence as well as erroneous legal advice, a challenge was filed before the tribunal, instead of against the said order of the appellate authority, against the alleged inaction of the respondent authorities. First up, the learned tribunal, by the impugned order, dismissed the original application on contest in view of the same being not maintainable, since there is a provision for challenge against the order under Section 54 of the West Bengal Land Reforms Act 1955, passed by the District Land and Land Reforms Officer, Paschim Medinipur, on February 8, 2024. Whose next para, learned counsel for the writ petitioners fairly submits that liberty may be given to the writ petitioners to prefer an appropriate challenge against the said order of the appellate authority. Upon hearing learned counsel for the parties, this court is of the opinion that the learned tribunal was justified in holding that the original application of the writ petitioners, in its present form, was not maintainable. However, nothing in the impugned order precludes the writ petitioners from preferring an appropriate challenge, was subject to limitation, and the father was entitled in law, against order number 3 dated February 8, 2024, passed by the District Land and Land Reforms Officer, Paschim Medinipur, appellate authority, closed, under section 54 of the West Bengal Land Reforms Act 1955 in LRP number 309 of 2023. Next para, with the above liberty, WPLRT 202 of 2025 is disposed of without interfering with the impugned order dated September 8, 2025, passed by the fourth bench, West Bengal Land Reforms and Tenancy Tribunal in OA number 1201 of 2024, LRTT. God rest you. প্রথম লাইনে
And similar orders may be passed in respect of item number 26, 27, 28 and 30.
নাম্বারগুলো দেখে
26, 27, 28.
in the slips please write the item number so that
And my LRP number will also change.
No, yes.
I am for 27.
briefcase number will also change. LRP number will.
So in my case, 27 LRP is
No, but the OA number and the date of the tribunal's order will also change. Dates are same.
But they
OA number. Can you please help us for 26, 27, 28 and 30, whoever is the petitioner, please give us just talk among yourself, give a chart, item number such and such, OA number and LRP. 3 columns, item number, OA, LRP. Do that by same order 26. নাকি আলাদা করে না 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 একদম ঠিক একটা করে পাঠান আর ওই যে চারটা ওরা করে দিলে সেইগুলো অনুযায়ী
Erroneous advice, my lord.
that will go. Give us synonym of erroneous.
Stop worship. Permits, my lord. Clients will have this.
We'll delete that. We have put in some other things also, so we'll delete that. In advertisement, all these things. Whoever is the petitioner, the petitioner should give the numbers.
Yes, sir.
আপনাকে একটু বসে যেতে হবে একটু বসে যেতে হবে এই পিটিশন থেকে নিতে পারবো এই Yes, 29 is yes, sir. What is the matter about Mr. Ghosh? Mr. Mahathir is there for the response.
My father was the recorded right. My father gifted my property in my name.
Right.
From the strength of the gifting,
What about the private respondents?
but I have served one of the since one of the certificate one of the other. Yes.
Affidavit একটা order record করে ওরা যেটা আছে affidavit of service filed to be kept on record since none appears for the private respondents, to afford an opportunity to the said respondents to contest the matter, let the same stand adjourned for the ওনাদের নামগুলো রেখে
Item number 31. Matter for the private respondent.
same applies. Although the private respondents are represented through counsel,
For the state respondent.
although the respondents state as well as the private respondents are represented through counsel, none appears to move the writ petition. Accordingly, let the same stand adjourned for the day. Please give your.
Private respondent. The state respondent.
Item number 32.
Item number
32 and 42. Mr. Banerjee is appearing. All of you are appearing. And Mr. Galib is appearing. Well, for 32 or 42, comma দিয়ে দেখিয়ে 42 দিয়ে এটা বটে। Give us some time to bring out 42 records. Yes, affidavit of service. 32 and 42. Yes, Mr. Bhattacharya. Yes, sir. We are taking up WPLT 209 first.
Yes. Annexures will not have same what happened there were original application filed by my client.
So you obtained an order before the larger picture Justice Stonemanship regarding
Did to obtain and my after the order
we are searching for you. We have been informed that.
Mr. Roy and Mr. Chatterjee told me. When the judgment came out in the Sarva, I could not find any similarity with my written notes of argument.
711 rejected order 711 application rejected by appellate court. Appeal lies 227 lies against the if it is plaintiff rejected. What sort of
many things? They something only Frost International was considered.
Yes, Frost International was considered,
and Frost is not on a completely different aspect to that. Mr. Roy told me that I completely I was there one of the parties, Mr. Jitendra Banerjee was there.
Yes,
he was led by Mr. Bhaskar Ghosh and
we were thinking about issuing a show cause to you too. Anyway, that may affect our judgment in this matter.
The file has shown me that these are written notes of argument that there is no.
Forget. Yes, Mr. Two matters.
One original application was one filed by my client, another by Mr. Banerjee's client. What happened, Millard? There was a suit which was initially filed by.
You are colluding with each other?
No, Millard. I not understand. There was a suit which was filed by Mr. Banerjee's client for declaration of title. Second declaration was that the concerned properties were not listed in this case.
So you are a party, state was a party.
I was a party.
And state was obviously a party. Not vested.
State was also a party. State was a party. Now, what happened? The suit was initially agreed. Then we got a title appeal was.
You are also on the state panel.
Yes. Now, then ultimately we traveled up to the petition bench in order 41 state second appeal. Now,
the suit dismissed.
Dismissed. Holding that the honorable division bench held that the second declaration is not vested in the state cannot be granted by the
division bench held this in order 41.
In order 41. Ultimately,
order 41 is not merger does not happen.
Not at all. But the honorable division bench gave liberty to my friend's client to approach the tribunal seeking appropriate relief. Now, they went to the tribunal. After
testing under which act?
Now, after receipt of notice from the tribunal, my client had also filed the original application before the tribunal. Both were heard, and by a common judgment, my the original application has been dismissed and his has been heard. Well, from that, there are two,
So the vesting in respect of him was reopened.
no,
How can that be?
there is not a declaration on part for a declaration. The declaration was passed by the tribunal that no property. The purchaser of the private.
So that way you are given a liberty.
That
When it's like
Shiva committee is asking for correction of revenue.
in his
Name. Tribunal says you do not have why committee. Shiva is not Shiva. But evident fact that land is a retained land of the private.
then why did you challenge?
So they have not challenged. I know. They have not challenged. They have challenged.
No, that it was held to have vested.
No, held to have
Not vested, not retained land of the.
But private property, the law is that
No,
We are not in the picture.
the ground of challenge is the ground of challenge is because the title appeal.
no, vesting has been reopened.
No, they clarify. They clarify.
Yes.
In the title appeal, the appellate court held that the sale deed by which I have purchased,
That level from the civil suit.
that the sale deed in respect of which by which I have purchased, that sale deed is bad. It cannot be, the owner property cannot be sold.
Right.
Against that, the second appeal was preferred. In the second appeal, my lord, at the admission stage, the honorable division bench held that one of the prayers in the suit is that the property is liable to be vested. So the civil court should not have entertained the suit at all.
Liable to be divested.
Vested. One
Oh, it
prayer
was not vested.
not liable to be vested. That was one of the prayer. Declaration that the property is not liable to be vested.
But it has vested.
No, it has not. Because I have purchased it not from the private door. Retained land, I have purchased.
Retained land.
Retained land, I have purchased. So appellate court, lower appellate court held that sale deed is bad. I challenge division bench to have a new point that the suit itself was not maintainable because the court did not have jurisdiction to try the suit. Categorical finding, I'll place the order.
Because of the divesting,
Because of the prayer of divesting, so the suit was not maintainable, the court should not have entertained the suit.
but not liable to be vested. How can that be thought before the court?
So that is the liberty given by the division bench. That was the prayer in the suit. That was the prayer in the
Latin 209, page 68. Then it comes to page 69. What was the relief sought for in the suit? The plaintiff prays for. The plaintiff therefore prays. Page 69, can you see the relief claim from the application?
Yes.
Can you see? A, the plaintiff has right, title, and interest jointly with the pro forma dependent number 1 and 2 to the property is schedule below. B, the suit property Katmati is not liable to vest in this case. This without the honorable division bench cannot be declared by a.
It has not been vested.
It has not been.
Why did you ask for this relief? This is a redundant relief.
This relief was paid in the suit. Because of this relief, the honorable division bench, while hearing under order 41, held that the suit itself was not maintainable. It should have been.
So right title interest, how can the
That is the finding of the division bench that
Ultimately,
of
page
that prayer,
74, we got
court should not have entertained the matter. No, I'll have to place this order. Okay, there are some findings which categorically said that the suit is not maintainable. And then you go on, in that view, my contention for the tribunal was that the findings of the
division bench? The order for tenure will vested.
Yes, can you see page 76? However, liberty was given.
Second ability dispose of on merits at the order for tenure.
But page 72 is not the question framed and answer. Can you not come to page 72 once? 72 minutes from reading. So paragraph 3, bearing in mind the aforesaid provisions.
Yes.
Aforesaid provisions, let us now consider whether the appellant could have instituted the suit before the trial court.
Page 72.
Page 72.
Yes, bearing in mind.
Mind the aforesaid provisions, let us now consider whether the appellant could have instituted the suit before the trial court, whether it could have tried the suit. Our answer is in the negative. For the reasons that follows.
That relief could not have been sought, but the title declaration has to be.
Regarding the entire suit, the court has said that your remedies for the tribunal.
If seek declaration of title, and tribunal has also declared your title.
Tribunal has said.
We'll set that aside.
But tribunal has said the property is not a vested property. Not a declared state from the record.
It was never vested.
Yes, it's not vested. It's a retained land. State filed that.
Why did you make that prayer in the suit?
Because the public were disturbing the possession, saying that the property is a vested property. There is one endorsement সাধারণের ব্যবহার in the record of right. সাধারণের ব্যবহার for because of that endorsement, it was claimed by the committee that it's a public property. Because of that, the suit had to be filed. Court said it cannot be done here. It has
You
to
got
go-
the declaration now from the
I got
of your
the
title also.
got the
from
declaration. Their contention now is that in view of the finding of the lower appellate court that the sale deed is bad, you have no rights. Now I say that because of the fact that the division bench said that the court didn't have any jurisdiction, it should not have entertained the suit. It was without jurisdiction. So that finding will not. It's a finding without jurisdiction. The nullity. That point has been accepted by the tribunal. But since the division bench said that the suit is without jurisdiction, the finding is also without jurisdiction. That is the only contention. That's the finding of the.
What the finding of the division bench that suit is not maintainable.
Page 72,
75 also.
72 we have placed.
I'll send
Then
you.
we'll have last page.
The last page is different.
Kindly come to 75, second paragraph.
Yes.
The decision is clearly distinguishable on fact. Here, the substantive relief claimed by the appellant inter alia was for a declaration that Kashmadiki had not vested in the state. Such a declaration could not be had from the civil court in view of the specific bar created by the 1997 Act. It was a tribunal constituted under section 4 thereof that the appellant should have approached.
So it was declared in your favor that it has not vested.
Not vested. That declaration of tribunal state after considering the affidavit filed by the state and the record produced that yes, it is a retained land, it can be
Retained land, no.
transferred, and not Devottor property can be transferred. The committee cannot challenge the transfer on the ground that the transfer is bad. Devottor property, private Devottor can be transferred for the benefit of the deed. The deed contains recital that it is required for the benefit of the deed. And they are relying on the observation of the lower appellate court, which says the sale was bad. It cannot be transferred.
They will let us hear the Mr. Mastry.
Yes, now we are kindly see Millard the impugned order once. Now let me place it, Millard. There's so many.
Yes, yes,
Yes.
yes.
Kindly see Millard the impugned order. Kindly see Millard the from the third paragraph, OA 778 of 2019 is an application under section 10 of the West Bengal Land Reforms and Tribunal Act filed by Shri Dodi Mohan Jiu, which is Dodi Mohan Jiu represented by Sheva Puja Committee. Well, Sheva Puja Committee is my client. Which is
It's a private Devottor property.
private Devottor property.
So what is the Seva Puja committee?
No, Millard, what happened, Millard? The local.
What is your locus standi actually?
I'll show Millard what is my location. I know, Millard, this will
The
be
Para people come and say we are the committee.
registered Millard, under the Registered Societies Act.
You go and get yourself registered, but you don't have any locus stand regarding that.
Application is filed by Dodi Mohan Jiu.
Was understood? Was there an Orponnama?
Yes, I will even if Millard,
By virtue of that Orponnama, is any committee contemplated?
no, but by virtue of the Orponnama, Millard, they are also not getting it.
You don't have any locus standi, forget about this. You don't have any locus standi to file the way.
I will show Millard. I have. I will show.
Sure.
Let me proceed, Millard. Legal points, Millard. Which is directed against the state respondents for inaction to consider and dispose of the application dated 27th April 2015 and 7th February 2019 for correction of record of rights and limited the name of the applicant in terms of the judgment and decree dated 31st July 2012 passed by the civil judge junior division Raigan Dinajpur in title suit number 284 of 2007 and finally affirmed by Honorable High Court in Calcutta in SAP number 538 2015 over the subject land which.
So both of you are seeking the same relief before the tribunal.
No, the same
Correction of record of rights.
Correction of record
Record
of
of in their favor.
in favor of the idol of the deity.
Sheva Puja Committee.
yes, exactly. So,
And they paid for
because they have
they
purchased.
saw a declaration that there is no vesting.
Recording in our name has already been done.
Yes, therefore you don't need not pay. Yes, fair. Please proceed.
Public report.
Why two properties? That's why two petitions.
No. Two different Millard. We objected to that.
Into capacity. We filed the way for the declaration. The purchaser filed for correct non-consideration of the correction.
One against their allowing their way, and another dismissing your way.
In my matter, he's the private respondent and he's.
Understood. One is against dismissal of your way, and the other allowing it. Yes. So this is a common judgment.
the public Devotto property and civil court rejected the claim of private respondents over the subject land. The fact is the case is in brief that the subject land was originally belonged to Deti Sri Dodi Mohan Jiu. One Nitya Krishna Bhattacharya will not kindly mark this line. Everything in this matter is dependent upon Mr. Nitya Krishna Bhattacharya. Was Shiva, and he has no right to divest the public Devotto land, but the private respondents executing some false deed allegedly purchased purchased subject from the power of attorney of the Shiva and thereafter recorded their name in LR record, but the never obtained possession for which the civil suit was filed. The above mentioned Shiva left the claim, and at present Shiva Puja committee has been formed by the local people to look after Shiva Puja of the deity. The civil suit has been dismissed and it is affirmed by the Honorable Court. The applicant filed the application on 27th April 2005 before 15 before the BL and LRO Kaliaganj block district Uttar Dinajpur for correction of LRO, but the concerned authority did not take any step for which this OA has been filed. Respondent number 4, 5, and 6 filed affidavit in opposition by stating that this OA is not maintainable. The Shiva Puja committee is no legal right. The right of Sri Nitya Krishna Bhattacharya has along been recorded in ROR till the property was transferred by the Shiva in favor of answering respondent. The said Devotto property was a private endowment. However, pursuant to the liberty granted by the Honorable High Court in second appeal, is the respondent number 4 filed OA being number 1012 of 2021 before this tribunal, that is Mr. Manager's client. It is stated that the degree passed by the civil court is without jurisdiction and hence nullity in the eye of law. The BL and LRO concerned has no obligation to make any correction in the record of right. Against this affidavit in opposition, applicant filed affidavit in reply. It is stated that legal heirs of the Shiva transferred the property, although the Shiva cannot transfer the property because he is not the owner. There is no but to initiate proceeding for correction of record of right. OA 1012 of 2021 is an application under section 6 state with section 10 of the WBLRTT Act filed by one Nimai Chandra Kundu. It is stated that the land is recorded in the name of Dodi Mohan Q, which is a private Devotto, and Nitya Krishna Bhattacharya was recorded Shiva. After demise of the legal Nitya Krishna Bhattacharya legal heirs transferred the suit property to this applicant along with respondent number 7 and 8 higher registered sale deed of 2005 for the benefit of the deity. After purchasing, the applicant and respondent number 7 and 8 are carrying pisciculture in the said property. Affidavit in opposition filed by respondent number 7 and 9 against the OA. It is submitted that the subject property is Devotto property and the Shiva cannot transfer the Devotto property. But the legal heirs of Shiva transferred this Devotto property without permission, and the Shiva did not perform his duty as Shiva. So the villagers, to protect the Devotto property, formed a committee in the name of Sri Dodi Mohan Jiu, represented by Shiva Puja committee. The private respondent filed title suit number 284 of 2000 for declaration, but it was dismissed and affirmed by Honorable High Court, Calcutta. These respondents filed application for deletion of the name of the purchaser, but the concerned BL did not take any step for the response. So this respondent filed OA the 7/7/2019. The LROR is erroneous and it should be restored to an earlier position. Then Millard arguments. Millard, kindly see Millard the next page. Millard arguments I'm skipping over. Kindly see decision with reasons. Kindly see, it is admitted position that the subject land belonging to one deity, namely Sri Dodi Mohan Jiu and one Nitya Krishna Bhattacharya, was recorded Shiva of that deity. And the property was Devotto property.
Firstly, we go through the observation of Honorable High Court Calcutta in SAT 538 of 2015, where the Honorable Court was pleased to observe that where was substantive relief claimed by the applicant inter alia was for a declaration that subject land was not vested in the state, and such declaration cannot be had from the civil court in view of the specific bar created in 1997 Act, and it was the tribunal which should have been approached. From the observation of the Honorable High Court, it is crystal clear that the civil court was without jurisdiction according to an observation of Honorable Supreme Court of India. India cited in 2005 Supreme Court cases 791 that where court has no jurisdiction over subject matter of suit, it cannot take up the case or matter, and any order passed therein is a nullity. Secondly, Shiva Puja committee formed by the villagers, and it is a registered under Society Registration Act, but it does not mean that Shiva Puja committee got the power to maintain the deity or to perform the work of Shiva. According to our, there is a Shiva, and this power has not been cancelled by Shiva by any authorized forum. The committee cannot suo motu declare itself as a Shiva. Practically, the committee does not relate with deity in any way. There is nothing to prove that the Shiva left the place permanently or does not perform the work. It is not clear to us that how the Shiva Puja committee has been aggrieved in the present situation. An aggrieved party is a person or entity whose personal property or financial interest have been negatively impacted or harmed by the actions of another party, statute or a court decision. But in this matter, no such thing occurred. Only some person formed a committee and claim something is not justified. As per above decision, it is our view that Shiva Puja committee has no locus standi, considering all such we are of the opinion that OA number 778 is dismissed. That is, my application was dismissed. Then you will kindly see. Now we go through the order passed by BLNRO Kaliaganj district, Uttar Dinajpur on 12 September 2005. It was mentioned that the deity is purely private in nature, and the name and the same order, it is mentioned that after receiving the auction, it is transferred. That an area of 20.78 acre of land was allowed to retain by the Rayat as on 15 February 1971, and rest 3.36 acre of land vested in the state, and the retained land schedule of Rayat is shown as Annexure D, and vested land schedule is shown as Annexure C. In Annexure D, it is shown that plot number 4, total area 4.4 acres, which is in the subject land, is a retained land. In view of that, it is crystal clear that the subject property is not a vested property under but a retained property of the private developer. Considering the circumstances, OA number 779 was dismissed and their application was not allowed. Now, we will kindly see below what is the case, what is their case made out.
So, Bhattacharya, in fact, this is a perfect order. Their title has not been declared by the tribunal going beyond its jurisdiction. Validity of their deed has not been gone into at all. It has only been held that it's a vested property of a private devotor. Pardon? Retained property. Sorry, retained property of a private devotor trust, and that you have no locus standi. And it was retained land, therefore it was not vested. Can be transferred. Can be transferred is not
Different question.
Not correctly.
Correctly.
Because the tribunal could not decide that.
Yes.
And you obviously have no locus standi. How do you have locus standi?
Locus standi.
First, satisfy us on your way. Then we go to theirs.
Both ways by these. Sorry, both repetitions are by.
my locus standi Milord comes Milord from Milord Order 32 of the Code of Civil Procedure.
Yes, let us see order.
Because Milord here, Milord, society Milord is representing Milord, not representing, is acting on the Milord, on the for the benefit of the Milord deity who is a perpetual minor. Who is a perpetual minor? Although Milord, I admit Milord, all those leaves are Milord are taken Milord for filing of a suit by the next scheme.
What is the leave here? You have not taken any leave from any court. You have given yourself the leave.
Original application Milord.
Self-proclaimed.
Original application Milord.
What original application?
Because
where is the leave? Had to seek a leave.
Yes, yes.
To represent the deity from a competent court.
Yes.
An explanation of Rule 1 says, in this order, minor means a person who has not attained his majority within the meaning of section 3. So it does not speak about perpetual minor is a legal fiction, Mr. Bhattacharya. You cannot import order 32 to a deity. It's a legal fiction. This appears to this applies to natural persons who has not attained majority because it has been defined here in the explanation. So therefore, deities are governed by the trust law, devotal law, public or private endowments, whatever law governs.
I cannot take benefit of section 34 of the Trust Act. I cannot do that. 92 is also not available to me.
You are a nobody. Nothing is available to you. You are a group of busybodies in the locality who claim themselves to be the Shevite.
No, not Shevite, worshippers. We never claimed ourselves as Shevite.
Sheva Puja committee.
Sheva Puja.
Go and do your Sheva Puja, form your committee, have your functions, but you cannot come here, you cannot disturb their right. You go and, instead of a Sheva Puja committee, you go and form a fan club of the deity and get it registered. You'll be the fans of the deity and worship the deity. Fan clubs are also registered, so they have a right over the idol. What sort of right do you have? Should have been dismissed with costs. Show your judgments. On what proposition?
Yeah, 1960. Kindly see paragraph 1 and then I will be skipping over to paragraph 17. Kindly see here the court was considering has recorded facts of 2 other earlier suits. Kindly see
this is on what proposition, Constellus?
Yes.
That Devotha property cannot be transferred?
No, not cannot be transferred. Even worshippers will not even
private Devotha.
Even in private Devotha.
This is relevant.
Yes. And this is a suit to challenge the alienation of a Devotha property. The Devotha was created by one Mokshoda Muni Dashi by 2 or Purnamas. She appointed herself as the first Shevite and certain named persons as subsequent Shevites. Thereafter, the Shevite was to devolve on the nephew of the settler, one Shital Chandra Das, and his heirs. The Shevite devolved of Shital sometime in or about 1944. During the lifetime of Shital Shevite, the Devotha property was sold. Shital died in or about February 1956. His only daughter, Molina Hajra, as Shital's heir, became the next Shevite. The suit has been instituted by her for self and as the next friend and Shevite of the deity. The parties implicated are a number of persons who dealt with the Devottar property. The claim sets out all facts leading to ultimately the sale of the Devottar property. Sheetal was Shevai created a lease as Shevai created a lease in favor of the defendant Gopinath Das on a monthly rent of rupees 5. The lease records the payment of rupees 250 the Selami. Gopinath subsequently assigned the lease to the defendant Nimai Chanda. Next line is very defendant. Defendant Rajan, purporting to act as a friend, next friend of the deity, instituted a suit against Sheetal for framing a scheme of management of the Devottar property and of carrying of Devashiva. In that suit, a consent decree was passed whereby a trustee was appointed with authority to create a mortgage of the Devottar property. Miller Rajan's suit, maintainability of the Rajan's suit was seriously questioned in this matter. Now, Miller, kindly see what is the answer given
In fact,
at page
these
70.
sort of suits are the consent decree should not be passed. The court should not permit a consent decree. Court is the guardian of the deity.
Now, Miller, these
How can there be a it's like in a probate proceeding if there is a consent decree.
Yes.
Anyway, this
Rajan's suit, maintainability of the Rajan's suit was seriously questioned in this judgment because Rajan being a third party. Yes. Kindly see, Miller, what is the answer given at paragraph 70. Yes. Can we see the legality of the lease and the question whether it is binding on the deity is
this
not
is 16, para 16.
I am extremely sorry. The suit number 98070. The suit number 980 of 1945 instituted by Rajan Sen in the name of the deity has been challenged on the ground that Rajan Sen had no authority in law to institute the suit. According to Hindu law, Shevai represents the deity and he alone is competent to institute a suit in the name of the deity. In exceptional circumstances, however, where the Shevai does not or by his own act deprives himself of the power of representing the deity, a third party is competent to institute a suit in the name of the deity to protect the Devottar estate. Dr. Das contends that such a party must be a member of the family or a worshipper and that a total stranger. In law, is not competent to institute a suit in the name of the deity. I do not, however, consider this to be the correct view in law. A worshipper or a member of the family has no doubt his own right to institute a suit to protect his right to worship, and for that purpose to protect the Devottar property. That is, however, a suit by the member of the family or worshipper in his personal capacity, and not a suit by a deity. The deity has also a right of its own to have a suit instituted by a next friend. As I understand the law, the person entitled to act as a next friend is not limited to a member of the family or worshipper. Anybody can act as the next friend, but the law requires that anybody other than Shiva instituting a suit in the name of the deity must be appointed as such by an order of the court. That is the law as recognized by
even by this you fail on two counts. Not appointed by an order of court. One. Secondly, there is no proof, factual evidence considered or adduced by you to show that the Shevai does not or by his own act deprived himself of the power of representing. You have alleged, but you don't find any discussion of any proof. So therefore, in any event, the tribunal could not grant these views. And you have not been appointed by a court, even in this judgment it has been held. You are self-proclaimed, and you say you are self-proclaimed bhaktas.
No, this line is also that deity has also a right of its own, to have a suit instituted by a next friend.
Arrange an interview with the deity, will speak with it.
That is not.
Exactly, that is our point. It speaks to people.
This speaks to
You are utter busybodies, Mr. Bhattacharya. You may worship the deity, but you don't have any locus standi in law. What is the wrong in the order? Any other judgment you are going to cite another judgment?
another is judgment. It is 95.
Give a copy to your learner.
Yes.
No, see. You get the copy, Mr. Bhattacharya. We request you.
Now we'll have everything airdrop.
From the very first sentence we continue. Before the first sentence. Yes.
Second page, Millard, admittedly, Jotindranath Chakraborty and others were the recorded owners of the suit property. They decided they dedicated the suit property in favor of the deity such and such for Devaseva out of the usufructs of the suit property. It is also admitted position that Shorvani Deva became the Sheva who sold this and transferred the suit property in favor of the plaintiff's father. The plaintiff's father prayed for a declaration of title on the basis of inheritance from the father who purchased the suit property from the said Shiva. In this context, a question came up for consideration before the courts below as to whether the plaintiff's father could acquire any title in the suit property by virtue of such purchase of the Devotha property from the Shiva. The suit property was dedicated to the deity. Deity is the perpetual minor. Sale of any Devotha property without obtaining permission from the district judge concerned is void. No permission was taken from the district judge for selling and transferring the Devotha property.
Legal necessity is an exception.
Legal necessity may not legal necessity.
But a proper suit has to be, your proper remedy might have laid before
because they have
their vendor is still alive.
Millard, their vendor is the power of attorney holder of the original Millard Sheba. Yes,
Vendor is not the power of attorney holder. Power of attorney holder is the power of attorney holder of the vendor.
No, power of attorney holder, Millard.
Power of attorney holder is not the vendor, he's the agent of the vendor.
He's the agent of the vendor.
So their vendor, if the vendor is alive, either against the vendor or whoever comes next in line of the Shebais, you could have filed a proper suit for management.
I say, Millard, the power of attorney.
You, in fact, don't have any custody to do anything. But as worshippers, pursuant to that judgment, you could have obtained the permission of the court, appointed yourself as the next friend, and then filed a proper suit for management and scheme. That is the only recourse you had, as per your judgments.
Yes. Millard, that is.
This is the law. The second judgment says this is the proposition of law, settled proposition of law, except legal necessity. But then you have to file a proper suit challenging his title.
Orponnama does not give any problem.
He filed a suit, which was the division mentioned. You did not file a suit challenging, or nobody filed a suit challenging his sale. Proper person was the Shebais who could have challenged that sale. Or somebody, worshippers might also have. Did not.
And Millard, last Millard, I will show Millard the person Millard, who has sold one of the Shebais. Millard, he was not even a Shebai. Even in that also, Millard, my locus standi is. How can I challenge that? Millard, I'll show Millard from there, Millard, Orponnama that he was not even a Shebai.
Well, we'll keep it part. Hard in part for further hearing. List the matter on. List the matter tomorrow. Yes. Please, ma'am. Why come back tomorrow?
Advocate matter because the tribunal he wants to be present. Individual.
No, no, that will create more problems for us. Whatever he has done, sufficient.